I'd like to call the meeting to order. Would everyone please rise? Pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Welcome, everyone. Township of Old Bridge Zoning Board of Adjustment meeting, June 5, 2025. Adequate notice of this meeting of the Old Bridge Township Board of Adjustment has been provided in accordance with the Open Public Meetings Act at least 48 hours prior to the commencement of this meeting by prominently posting in the municipal complex an announcement giving the time, the date, location, and the agenda of this meeting, by mailing such announcement to the Home News and Tribune, filing such a copy with the municipal clerk, and finally posting on the agenda on the municipal website. Vice Secretary Percelli, could we have a roll call, please?
Certainly. Mrs. Andrews? Absent. Ms. Chevalier?
Here.
Mr. Izzo? Absent. Mr. Scogno?
Here.
Mr. Stoner?
Here.
Ms. Testaverde?
Here.
Mr. Singh? Absent. Ms. Gomez? Here. Chairman Sullivan?
Here. Thank you. I would warn the attorneys that we have, as you can see, 6 seated members this evening. So if that has any influence on your votes, you'll know ahead of time. Okay? This meeting is being televised on OBTV Channel 15 here in the Township. Simultaneously, this is on YouTube Live. If you ever want to refer back on YouTube. I would ask everyone here in the room, I'm sure everybody has one of these, I would just ask you to please mute them so we don't interfere with the testimony this evening. We're going to follow the agenda as it is written, if you have a copy. We have just a couple housekeeping items to do, and it's followed by 4 applications this evening. Now, I would tell all the attorneys that by rule, we end our meeting at 10 o'clock for open public comments, and then officially at 10:30. That would carve this up to about 35 to 40 minutes per application, and I'm going to have to cut you off. I'm a little flexible, but I do want to be fair to everyone and kind of offer the same time. We have our 2 stenographers this evening, and I remind both of you, if something comes up, please just throw something at me and get my attention, and I'll take a pause. Having said that, we're going to move board onto the minutes, and we have the minutes of May 15th, 2025. Absent any comments for corrections or deletions, I would ask someone to move them for adoption.
Chevalier will move it.
Is there a second?
Second Stoner.
Roll call, please.
Ms. Chevalier?
Yes.
Mr. Scogno?
Yes.
Mr. Stoner?
Yes.
Ms. Testaverde?
Yes.
Ms. Gomez? Yes. Chairman Sullivan?
Yes. Counselor, we have 3 resolutions this evening. 62-2024Z, Alan Blanchard, C variance. I would introduce Jerry Dasty, our counsel, this evening. Sir?
Thank you. The Blanchard application was on block 17010, lot 9. Oh, I'm sorry, excuse me, thank you. Block 17010, lot 9, 1 Victoria Drive. This was an application held over 2 meetings to obtain a variance to construct or to get approval for the previously constructed pool house, which was installed about 1 foot from the side yard, where 10 feet is required. There is no electric provided to the shed. There's no plumbing improvements for the shed. And it has been approved by the HOA.
Thank you, Counselor. Board members, you've heard the resolution. Someone move it for adoption.
Move it, Scogno.
Is there a second?
Testaverde.
Roll call, please.
Ms. Chevalier?
Yes.
Mr. Scogno?
Yes.
Mr. Stoner?
Yes.
Ms. Testaverde?
Yes.
Ms. Gomez? Yes. Chairman Sullivan?
Yes. 08-2025Z, Michael Scarpa, also a C variance. Counselor?
Thank you. This is affecting block 26028, lot 53 at 177 Park Avenue. The application is to obtain approval for an above-ground deck, which was installed without a permit. So I was asking for a permit afterwards. It's in addition to a prior approval granted by the zoning board to install a shed and gazebo. It's a standard C variance application.
Board members, you've heard the resolution.
Move it, Scogno.
Is there a second?
Second Stoner?
Roll call, please.
Ms. Chevalier?
Yes.
Mr. Scogno?
Yes.
Mr. Stoner?
Yes.
Ms. Testaverde?
yes,
Ms. Gomez? Chairman Sullivan?
Yes. And finally, 092025Z, Alcedes Vera. It's a C variance.
Mr. Vera, Block 4187, Lot 1.18. You may recall his backyard fronts Route 34. He needed to obtain approval to construct an 8-foot vinyl fence in the rear of the home along Route 35, but inside the existing fence, I guess, which was installed by the DOT along Route 35. And it's to assist in keeping his dogs and his kids in the backyard. There was no opposition to the application.
Board members, someone move it, please.
Chevalier, I'll move it.
Is there a second?
Testaverde,
Ms. Testaverde, roll call, please.
Ms. Chevalier?
Yes.
Mr. Scogno?
Yes.
Mr. Stoner?
Yes.
Ms. Testaverde?
yes,
Ms. Gomez? Chairman Sullivan?
Yes. Council, we'd ask you now to swear in our professionals, Mr. Dargy and Mr. Hallahan.
Gentlemen, do you each swear or affirm to tell the whole truth so help you God? I do. Thank you.
Thank you, sir.
Yes, sir.
We'll start with our first application. It's 63-2024Z. It's 1103 Route 35 LLC. It's a R5 medium high-density residential. It's Block 24, Lot 1100, physical locations 1103 Highway 35. This is on an appeal. Applicant seeks to appeal zoning officer's denial dated 10/7/24 of a zoning permit to establish a gentleman's club. Mr. Palmer?
Actually, Rick Brodsky on behalf.
Just tap that until it turns green. You got it now.
Yes, Mr. Chair, Rick Brodsky on behalf of the applicant. I'm with the law firm of Van Stel, Grimm and Aaron, and I am here. Mr. Palmer was former counsel. Okay. Good evening, Mr. Chair, members of the board. Rick Brodsky, again, on behalf of the applicant. As the chair indicated, the nature of the application before you this evening is an appeal of the zoning officer's determination, finding that the pre-existing non-conforming use at the property was abandoned at some point in time. And I'm going to go through a little bit of the background just so we're all kind of up to speed as to where we are and how we ended up here. But basically, you know, this is an adult entertainment venue, so, you know, regardless of your feelings as to that type of use, we've got, you know, there are vested rights, there's applicable law, and indeed, we think you'll be, the evidence is quite compelling in terms of maintaining that pre-existing non-conforming use. So to be clear, we're not challenging any interpretation, right, of the zoning officer. That is, we're not suggesting that the zoning officer, that this use, the adult entertainment use, is permitted in the zone. Indeed, we understand that under your ordinance it is not permitted. However, as you all well know, the law protects pre-existing non-conforming uses, uses that existed either prior to the implementation of zoning and or at least prior to the introduction of the zoning ordinance, the local zoning ordinance, which made adult entertainment uses not unpermitted uses in the zone. Now, here in Old Bridge, your ordinance currently provides that adult entertainment uses are not permitted anywhere in the zone, anywhere in the town, I'm sorry. Of course, subject to rights that were attached as a pre-existing non-conforming use. And indeed, this use at this location has existed for decades, right? And so clearly, and I don't think there's any contention from the zoning officer's perspective that this was not a legally permitted use for all that time, for all those decades of time. The issue is that there is an assertion that at some point those uses, that the right to that pre-existing non-conforming use was abandoned. And so what, I'm going to give you a little factual background, then I'll just talk a little bit about the law, because I think it's important. And I know we have a limited time, but as I said, I think it's important. This property, as I said, has been used for this use for decades, as far back as at least 1992, probably more. It operated under the name of Jersey Girls. In or about the prior owner of the property, the principal of which is Anthony Spilero, who's here this evening to testify. He owned and operated the site beginning in approximately 2022. He acquired it from another family member, and again, he acquired it as an ongoing adult entertainment business. Okay, acquired the business, acquired the real estate, acquired the liquor license. Everything was transferred to Mr. Spilero's entity in 2022. As I said, the liquor license was transferred by the town legally, and the operation of the enterprise as an ongoing adult entertainment club continued upon Mr. Spilero's acquisition of the property. At some point in time, before Mr. Spilero sold the property to my client, Mr. Olin, who is here this evening as well, in the fall of 2024. At some point prior to that time, for various business-related reasons, Mr. Spilero had made a decision to cut back on the operation a little bit at the site and limited the operation without any permanent decisions as to the future use of the property, but made a decision to at least temporarily focus on private parties with adult entertainment. And as you'll see as we go through the testimony, that use continued right up until the sale of the property in October of 2024. In fact, you'll see in the documentation and the exhibits that we're about to submit that there are contracts in there for these private parties basically about a month before the property was sold. So always continued to operate, kept the property maintained, kept all licenses in place, kept the liquor license in place, the food licenses in place, maintained and improved the property, the physical real estate, and that's how it proceeded through about until October of 24, when it was sold to Mr. Olin. So you'll hear in the testimony that that as part of the sale, of course, and we're submitting a copy of the contract, what was sold was the business, the real estate, the liquor license. No dispute there. Never was there any decision or demonstrable intent to abandon the ongoing use. Too valuable, right? And in fact, as the property was being marketed during 2024, there was a broker that was involved, that was hired by Mr. Spilero, because at some point he made a decision to explore the sale of the property and the business and the liquor license, and that's what ultimately came to fruition. And there was a business broker involved who has done this type of work for many years, and that's Robert Gillis. He's here and will give the board testimony as to the marketing of the property. It was obviously marketed as an ongoing business, liquor license, sale of the real estate, et cetera, et cetera. No changes, again, no intentions to abandon any portion of the use, albeit there was some, a little reduction. There was some reduction and a focus change during the term of that marketing of the property throughout 2024, but never any closure of the property. Utility bills, everything we have that we're going to submit. And the significance of what I'm talking about, and the board will see, and Mr. Dasty will review when he has a chance to review the brief, is that when you have a situation, the law is fairly clear on this. Actually, it's very clear. In order for there to be an abandonment of a pre-existing non-conforming use, usually as lawyers, things are not so clear. This one's pretty clear. So the law, both in the municipal land use law and the case law interpreting the municipal land use law, as well as the Old Bridge zoning ordinance, are all very consistent. In a nutshell, right, for a pre-existing non-conforming use, and again, we're not taking the position that the use is permitted. We're saying it's a pre-existing non-conforming use. In order for there to be a classification of an abandonment of that valuable use, regardless of the type of use that there's two prongs that have to be proven. One is an intention to abandon that use. It's very important. It's got to be an intention to abandon the use. For example, if you read the case law, someone can close the business, they can go on vacation, they can take a break, they can close for 6 months, 8 months, 10 months, whatever. It doesn't mean that they intend to abandon that use, permanently abandon that use. The rights are not expired unless and until you can show an intention to abandon that use. What's the obvious way you do it? You change the use to something else, right? You start selling clothing, you start doing something else in place of the pre-existing non-conforming use. The second component of the proofs is that there has to be an overt act or failure to act by which such an intention is carried into effect. And that's what I was talking about, changing the use, talking about doing something totally different. And that's why the testimony is so important in terms of what was the intention of the owner with respect to the use here. And more importantly, or the most important testimony you'll hear is from the prior owner, right? The prior owner, prior to my client, Mr. Spilero, who's here, because that's the time during which it appears that the zoning officer concluded that the use had been abandoned, okay? So, all very important. We believe that all of that testimony and evidence will show that, as a matter of fact, that there was neither prong of that those legal requirements for abandonment have occurred. No intent to abandon, no independent act showing the intent to abandon. Now, I do want to note that I don't think it's relevant here, but in your ordinance here in Old Bridge, it essentially mimics the case law and the statutory law, except there is an additional provision in the Old Bridge ordinance which talks about the intent to abandon, talks about all these other things I talked about, and also has additional language which says that closing the business for a year, right, discontinuance of the use for a year, provides prima facie evidence of an intent to abandon. Now, I had to look up because I don't remember from my law school days, right? But prima facie essentially means that it's rebuttable. In other words, that's a good start. It means that, there's a basis to say, hey, we think you abandoned. You haven't been there for a year. And so we need you to tell us or show us why you never intended to abandon, that your intention was always to come back or sell the business to someone who was going to come back, which was always the case here. Again, not really applicable to our situation because it was continued to be operated, number one, with respect to the adult entertainment private parties, and two, the 1 year did not come into play. But I just wanted to throw that out there. And then when you're talking about the standard of proof in these kinds of cases, in terms of whether there's been an established intent to abandon the use forever, and whether there is an overt act showing that abandonment, it's by a preponderance of the evidence, meaning more likely than not. And so, a little legally technical here, but I thought it was important because, you know, it's a little bit, not so much a typical case that the board gets to see. So, unless the board has any questions, what I'd like to do is have our first witness come up, and again, that first witness is Mr. Spolero, who was the prior owner of the business and property from 2022 to 2024. And remember, he acquired the business in 22 from a family member, so he's familiar with the long history of this property and how it has been used for going back for decades. So, Mr. Chair, does that work?
By all means.
Okay.
Before the gentleman starts to testify, but come up, just a little housekeeping. We received the benefit last evening of an epistle from Mr. Brodsky. It's about a 10-page brief, very well done, and about 120 pages of exhibits, none of which, until about an hour and a half ago, was I able to even look at.
Understood.
So what I think we're going to do and advise the board, I don't know that we're going to finish the testimony tonight anyway, but I will, between now and the next meeting, review all of this and provide a response to you and a copy of Mr. Brodsky. My response won't be suggesting how to vote. My response will simply be to the issues that are in the letter, in his report, okay?
Sure.
So you know.
Perfectly fair and understood. And Mr. Dasty, so before we begin with Mr. Spolero's testimony, does the board mark exhibits that have been submitted, or we need not mark?
As you want to go along, Mr. Brodsky, we can do that, sure.
Okay. Well, what I'd like to do is mark the what is
Sure.
the epistle that you mentioned. I'm not familiar with that word, but and I have
That means good news.
I have a well, what I want to submit are the exhibits that were attached to
Yes,
the brief.
I understand.
Right? And so, and we have some copies that we can give out to the board.
Wonderful.
So, and we've got them all, Nicole nicely tabbed them and all that kind of stuff, so the
Since you
board
have them
members-
all,
Yeah,
and they're all of the attachments, we'll just leave the whole thing as A1. Is that all right?
that's perfect.
All right.
And then that it could be sub-exhibits A through N.
A, B, A, C, right.
Right, okay? That's
Okay.
perfect. That works
I'd
very
like to have a
well.
pound, thanks.
Okay. Okay.
Sir, let's,
Sure,
who's
I'll
going
just
to
identify
testify?
myself. I'm John Hogan, attorney, Wilentz, Goldman, and Spitzer, on behalf of Anthony Spolero. I handled Mr. Spolero.
Who's testifying?
So I'm going to be introduced, Mr. Brodsky is going to be representing Wadering my client, but I just want to indicate who I am and why I'm sitting here. I'm his counsel.
Okay, sir, would you raise your right hand? Do you swear or affirm to tell the whole truth and nothing but the truth? I do. Okay, give us your full name, spell your last.
My name is Anthony Spolero, S-P-A-L-L-I-E-R-O.
S-P-A-L.
L-L-I-E-R-O.
Evan? You say Evan, your first name?
Anthony.
Oh, I'm sorry, excuse me.
No worries.
Counselor, I didn't catch your name.
John Hogan,
Thank you, sir.
thank you.
Good evening, ladies and gentlemen.
Good evening.
Thanks. Okay, Mr. Spolero, if you would, I might call you Anthony as we go along. That's just the way I am. What's your involvement with this matter?
I'm the former owner of Jersey Girls.
Okay, and you heard my little background and opening that I presented to the board. So to the extent the facts were relevant to you or your operation, was I accurate in what I presented to them?
Yes.
Okay. All right, so let's move forward. When did you acquire ownership in Jersey Girls?
In 2022.
Okay, and that was from your father?
That was from my father, yes.
And it had been operated as Jersey Girls for a long time?
I had the name Jersey Girls, but prior to that, it was operated for 30 years.
Okay. And when you acquired the business, it included the business, the real estate, the liquor license, the equipment, the contents, all of that, correct?
That's correct.
Okay. And how do you describe the nature of the business that's been there for all these decades?
So live entertainment, adult venue that specializes in live, dancing, that serves food and drinks.
Okay. And it's been used since that time. When you acquired the property and the liquor license and the business in 2022, I assume you had to get the liquor license transferred into your entity's name, correct?
That's correct.
Okay. And you applied and it was approved by the township without an issue?
That's correct. I had to go for fingerprints, meet with the Old Bridge Police Department, do a whole investigation, because when you have a liquor license, I learned from a very young age that it's a privilege in New Jersey to have a liquor license. So I had to make sure that I took all those necessary steps to get the approvals.
Okay. And
And the license then was transferred to me at the Township Council.
yep. And any issues in the transfer? Anyone alert you with respect to anything involved with the use of the property?
No.
Okay, no issues. Did anyone object to the transfer of the liquor license?
No, I think I got everybody to say yes.
Okay, all right. Did you ever, so that was in '22, did you ever apply for any sort of zoning permit or change of use for the property during your ownership?
I did not.
Okay. And just by way of history here, back in 2017, I know not directly relevant, but just to complete the picture, a prior family member had brought an application, right, to change the use of the property to some residential use, correct?
Correct. They came in front of the board for apartments.
What happened then?
The zoning board denied it.
Okay. And was there public involved in that?
Yes, there was. A lot of the residents came out and did in support of the apartments, and they were beautiful. I don't know if anybody was still on the board at that time, but they were very nice. They preferred to have the gentleman's club, and I believe some of them even testified to that as well.
Okay. Now, during the pendency of that application, after that application was denied, the former owner, your family member, continued to operate the gentleman's club in the same way as it always had been.
That's correct.
Okay. And you continued that operation when you acquired it in 2022.
That's correct.
Okay. And in conjunction with the operation of the business, you had an active website, and the business was promoted as a local gentleman's club up until you sold it to my client, the current owner, Mr. Olin's entity, in '24, correct?
Yes, I was still operational and hosted all private parties and events.
Okay. So when you took over the property and the business in 2022, I know, or tell us, the operation was essentially 4 to 5 days a week and that type of thing. And then just kind of describe what went down in terms of when you made the decision to focus on the private parties.
So in 2022, 2023, I was open 5 days a week. I was there a lot. And then subsequent to after that, I got a notification from the township, from the state ABC, which is the Alcohol and Beverage Control, that they were coming in as a complaint was filed from the Township of Old Bridge Police Department. Met the Township of Police over the ABC at the site, and they said that they were there to investigate an underage kid that came in using a fake ID, and I guess he got into a altercation with some of the staff there, and he was asked to leave. At that time, he called the police. The police did respond. They arrested him for having that whole fake ID or however it was. And then after, at that point, I said to myself that if I'm currently not going to be able to be there running that place 5 days a week, that I'm going to change the operation a little bit where I'm going to protect myself. Because as we know, a liquor license in Old Bridge is very valuable. It's up to $500,000. So I said to myself, I'm going to limit my exposure. I'm going to protect my interest and protect myself. And I made the best business decision at that time, which I feel is the best decision moving forward.
And so essentially, if I understand it correctly, you kind of reached a point where you have other businesses, you have other properties, and you made a decision to temporarily cut back a little to focus on private adult entertainment parties while you decided what your next move would be.
That is correct, yes.
Okay.
I'm involved in many other businesses that take my time.
Yeah, and so, and then, and some of the things you were thinking about was whether you were going to continue operating yourself, whether you're going to go back to the full-time operation or the 5 days a week yourself, whether you weren't going to be able to do it and sell it to someone else who would have the time and inclination to do that.
Absolutely correct.
Okay, but certainly you never had, or tell me, did you ever have any intention of permanently abandoning the rights to that, to utilize the property with that pre-existing non-conforming use that existed for 40 years?
No, never.
Okay. And so during that 2024 period, for when you started doing focusing on the private parties, you had a number of contracts which are included what we've been marked as exhibit, what did we mark it? Exhibit A1. And it enabled you to have more control over what was happening at the site.
Absolutely. I was very selective, to, like I
Okay.
said.
All right. And during the pendency of your ownership, you made all necessary repairs to the property, you kept it maintained, as you do with all of your properties, right? I mean, it's a source of pride for you. And you had the roof replaced, you had new doors installed, you had all of those things because you knew the business was going to continue. And
That's correct.
Either for you or someone else.
Yeah, there was times that, like I said, changing ceiling tiles and back doors, like you mentioned, the roof. I always had advertisement on my outdoor sign, private parties. It was on my Instagram page, social media, things like that as well.
And you paid for food license here in Old Bridge to continue, right?
Yes,
Kept your insurance intact,
absolutely, yes.
and the liquor license remained intact and unchanged through the entirety of your ownership.
That's correct, because like I said, with the liquor license from the ABC, yeah, it was active, and I had all the necessary licensing that I need to stay active.
And you kept everything. You kept the business fully stocked, right, in terms of alcohol and beverages, and I don't know. Did you keep food, or did food come in?
Yeah, so we had a freezer, so we had food as well, but the bar was completely stocked with alcohol because, like I said, if people were coming in and having private parties, that was my obligation to provide, alcohol beverages.
Okay. During the time that you owned it and operated the business from 2022 to 2024, did anyone from the township ever approach you to say that you were doing something wrong, that you were not open, anything like that?
No, nobody ever approached, and like I stated, every year I had to come to the Township of Old Bridge, to the council. I had special restrictions on my license, so I had to come to the council in person and agree to all those conditions that were onto the license.
Okay. And in preparing for the hearings, we had gone over all of the documents in terms of the contract for sale to my client and a bunch of other things. And one of the things we looked at were some submissions that were made pursuant to Chapter 91, right? Requests from the assessor for income and expense statements. And your accountant filled those out in a certain way. And indeed, there was an entry on those Chapter 91 responses that had the word vacant on it. And I know you spoke to the accountant, and we actually, within A1, we have a letter from the accountant which explains that. So maybe you can do that for the board.
So my accountant, who's the Vertis Group out of Princeton, they handle all my books, they file all of my taxes, things like that. They filed all of my sales tax of all the parties that I had in 2024, all my taxes in open 22 and 23. And at that time, I was owner occupied. So I didn't have to pay myself rent. So when he filled out those documents, he put clearly onto those documents owner occupied as what it was stated. So that's what he told me, how he did that.
Right. And so it's Exhibit N for the board, Mr. Chairman, the board members. Exhibit M. Exhibit N has two documents, or a couple of documents in it. One is the letter from the accountant, which talked about the rationale for doing that, and then also the income and expense statements that were submitted, which both say right clearly on the first page, property is owner occupied, right? And that was accurate.
That's correct.
Just proceeding along, when you finalized your decision that you were going to sell the business to my client, the current owner, you entered into a contract, and that contract provided for the sale of the gentleman's club, the adult entertainment venue, with the real estate, with the liquor license, with, I guess, contents, furniture, equipment, et cetera.
Correct.
Okay. And
And just one more thing for that I just remembered. So my accountant also told me, and when we spoke about it, for those tax records, because I know Mr. Houlihan mentioned that to me when we spoke. It was vacant in the sense of there was not a third-party tenant. Well, I just want to make sure that we're clear. It wasn't that I was still a owner operator and things like that as well.
which is why he put owner occupied, right?
Correct. Yeah, I just wanted to make sure we clarify that.
Right on the first page. Right. Okay. Now, you signed the contract, Mr. Olin signed the contract, it was supposed to close, and the contract was signed in May of 2024. You continued to operate with the private clubs, still trying to decide how, you would proceed in the future, but clearly Mr. Olin was a candidate who was interested in operating not just for private parties, but the way it had always been operated.
That's correct.
Okay. It ended up closing, I guess, on or about October 9 or so.
2024, right? Yeah.
2024. And in conjunction with the closing, did you ever speak with the fire inspector, Mr. Miller, regarding the operation of the business?
Did. So before I get to that, I just want to mention, so prior to closing, I received a phone call from the Township, why can't I think of, what's her name? Township clerk. Thanks, John.
Township what, I'm sorry?
The Township clerk.
Clerk.
And she stated to me that at the time, when we were transferring to Mr. Olin, that there was an ordinance in place that stated that I wasn't going to be able to transfer that liquor license to a third party. And I asked her why that was, because that never was mentioned to me, and they transferred my liquor license and property in 2022. So she stated that her computer system was too old, and she had to look into it to see what kind of paperwork or whatnot she was going to find to allow that to happen. I explained to her that my family won that in Middlesex County Court many years ago with a Middlesex County judge, and that was ruled unconstitutional. So after that was said, she called me back probably about maybe a couple hours later, maybe an hour later. This was prior to the meeting, and she said that the township attorney was sick and ill, and he couldn't be there. So we had to delay it. So I just wanted a little bit of background on that aspect of it as well, of where this all went.
And then, was there any issue raised with regard to the operation of Jersey Girls with regard from the fire inspector or anyone else?
Yeah. So after this all transpired with Mr. Olin reaching out to me and we closed, and he stated to me that he wasn't able to get his CCO, that he was denied because it was an abandoned use. So I was kind of surprised when I got that. So my first call, I believe at that time, was to Mr. Houlihan. I spoke to Mr. Houlihan on the phone, and I asked him, told him I was the previous owner, and why he was coming up with that it was an abandonment of use. He stated to me on the phone that I had a for sale sign on the property. He also said that an income and expense report showed $0. Tried to give an explanation of why it showed him $0, but in his mind he said to me that he disagreed, and we left off basically in just that I was going to move forward in a different direction. When it comes to Thomas Miller, Mr. Olin reached out to me. And he said to me that the township officials came in to do their new paperwork. So you have to get a state fire license, you have to register and things like that. So when I spoke to Mr. Miller on the phone, he stated to me that he knew that I was operational. He knew that I was not vacant. That was his words. He knew that I received all of my, my fire permits, all my inspections, all the time. I never messed around with that, especially since I'm doing private parties. And then I did let my attorneys know that, and I'm sure, you know, Mr. Houlihan could go back to his, Old Bridge has recordings, but I do have that on audio recording as well for Mr. Miller, and I have some protection of the conversation that I spoke about with Mr. Houlihan as well.
So Anthony, anything else that I didn't mention in terms of, or that we haven't hit in terms of, if not, let me recap. So, right, you operated the adult entertainment venue as Jersey Girls, right, from 2022 to 2024, after it had been operated for decades prior for the same use. 2024, you were trying to figure out from a business perspective what you were going to do, where you're going to sell, where you're going to operate it full time, and so you decided to focus on the private parties, the adult entertainment private parties, correct?
That's correct.
Was there ever a time that you ever, you know, had any intent to somehow abandon those pre-existing non-conforming rights to operate as a adult entertainment gentleman's club, the way it had been operated for 30, 40 years?
Exactly. And I never abandoned it. I have, like you have some documents in front of you. I, you know, have proof of contracts that I did. I paid sales tax, like I said, income, federal taxes, my accountant did. We have videos, so no, I never abandoned the use. It was always operational, and I just made that business decision at that time to protect myself a little bit with some other businesses and liquor licenses that I have.
Okay. And then, and when you marketed the property and sold to Mr. Olin, you marketed it as
Pre-existing, non-conforming use, and it was a continuous gentleman's club.
no restrictions as to the use.
No restrictions, no.
Questions for Mr. Spilero?
Can I, Chairman?
Yeah,
Just
go ahead, Council.
just a couple of, sir, what's the name of the company that you owned, that owned the business?
Route 35 Associates LLC, doing business as Jersey Girls.
All right, Route 35,
Associates LLC, doing
And-
business as Jersey Girls.
And Jerry, let me just clarify. So that was for the owner of the liquor license and the furniture and fixtures and the goodwill, and then the real estate was in a separate entity, right?
That's correct. The
what was the name of the business that owned the real estate?
1103 Lawrence Harbor Corporation.
And who was 1103 Lawrence Harbor Corporation? That was you?
That was me.
Was that your father before you?
It was not.
We have, and we'll go over all of these later on, but we have Chapter 91 records, which indicate that this is like from 2015, addressed to 1103 Lawrence Harbor Corp. At 301 Dorn Drive in Shrewsbury. Was that you?
It was not. That was my grandmother, and she passed away. So the estate, after we probated with Monmouth County and the judge, I was left the property.
I guess my question is, if your grandmother owned that corporation, but then you owned the same corporation in 22, 3, and 4. Is that what you're saying?
Yes, the corporation was left to me.
Membership interest?
Member, yes.
Or the,
Okay,
or the
that-
stock
that's
shares?
what I
or
meant to
shares.
get
No,
to.
that's, I should have pointed
All
that
right.
out.
And in the 3 years that you owned the 2+ years that you owned the business, you've owned other businesses with liquor licenses and businesses that had to comply with Chapter 91?
Is that, you're talking about for the income and expense
Yeah.
report? Yes,
Yeah, you've been doing that for a while?
that's correct. Well, my accountants have been doing that for me for a while.
Okay. Well, okay.
So I pay them a lot of money to do that.
The corporation that owned the land, when you had 1103 Lawrence Harbor, did that rent it to another of your companies?
It did not.
Okay, so there was no other tenant. You were the landlord, you were the owner and the tenant.
That is correct.
In 2000, oh, you don't have it in 21, that's right, excuse me. in 2022, for the year 2022, you filed the Chapter 91 income statement on your behalf?
My accountants did at the Vertus Group.
Okay, and it seems to be signed by someone who says managing member on, I think it's 9/6/23, or it might be 4/6, I'm not sure, okay? Now, it references the page Schedule A, which is to be the income page, right? Yes? Do you need a copy of this to follow?
I do not know.
Okay.
What year, what year?
22.
Okay, 2022, yes, I see it.
Okay. Now, you understand that whoever signs this, and it was your managing member, there's a certification on page 2 that he's certifying the responses that are on that document, right? Okay. Let's go to Schedule A. What does it say is the status of occupancy for 2022?
It says V for vacant.
Vacant, right? It doesn't say it's occupied, it's vacant.
It says V for vacant.
Right, okay. And what does it say is the average rent received by the property owner?
0.
How about base annual rental per square foot?
It says not applicable
Right.
due to the fact that I'm the owner and the tenant.
No, it doesn't say that. It just says not applicable. Doesn't anything else on that.
Well, you're asking about the income.
I'm looking at Schedule A.
Right,
It just says not, there's no explanation. It just says NA.
right, because I didn't rent it to a third-party tenant. So
Where
if
does
there was a
this-
third-party tenant that was involved in that, then it would be listed. But I was owner occupied.
Do you know what the purpose of filling out these Chapter 91 forms is for?
It was under what my accountant explained to me is if you have a third-party tenant, you're reporting what income is made from rents or income from the property.
Do you understand that the determination of how much income a business receives is part of the equation that determines the fair market or the assessed value of the property, right?
I don't know that.
Okay, okay.
What I do know is that I was open in 2022, 23, and 24 and filed federal tax returns showing that business made income and I filed all my necessary taxes with it.
Okay, can you
My
turn?
accountant did make any kind of clerical mistake back in 22 or 23, I'm not sure, but maybe that's, the township never notified us to ask us to, as they knew we were open, because the Township of Old Bridge and the police department came in and did an investigation as well. So if there was an issue with the filing of how my accountant did that, then maybe we could have,
Your attorney is telling you we have a limited period of time.
Oh, okay, I'm
If you
sorry.
don't mind answering my questions.
He's
and
passionate.
he's Italian, I understand that.
not, yeah.
Does it say Dasty
Just
here?
wanna
No,
be
it
fair.
doesn't. All right. Now, looking at the Chapter 91 for 2023, can you turn to that one?
Jerry, can I just ask him one question on the 22 form? Real quick, one question, yes or no. On page 1, Anthony, of the 2022 Chapter 91, right about in the middle of the page under comments, what does it say there?
It says property is owner occupied.
Okay, that's it.
Well, let's look at the same one again. On part number 3 on page 1, we're looking at the 22 report. Do you see it? Right? You have the 22 report in front of you? First page?
yes.
Okay. First page, part 3, statement of income. Schedule A must be completed. And it references in the upper left-hand corner the property owner, which is your corporation, 1103 Lawrence Harbor Corp., right?
That's the real estate company.
Okay, so, okay. Well, is there one that was ever filled out for the business?
Not that I'm aware of.
Okay. So the real estate company, who paid the real estate taxes on this property? Which corporation?
1103 Lawrence Harbor Court.
Where did 1103 get money to pay the taxes? If there was no lease?
That's a good question. So, several businesses that I have, makes sense sometimes where I have net gains and losses. So if I took a check from another business and I loaned it to 1103 to pay those real estate taxes or whatever it was, I got the deduction on the other end. And then I would take the loss or however as my accountant set it up.
Are you saying that 1103 didn't make any income in 2022?
1103 did not make any income as far as income for rental property or tenant. No,
I didn't ask
zero
you-
income.
Sir, I didn't ask you
1103 made
about
zero
rental
income.
property. Schedule A doesn't talk about rental property. It talks about statement of income. And you said effectively none.
I think what he's asking is that.
No, this is what I'm asking. Please, Mr. Bronsky, if you don't understand my question, let me know. Schedule A, it doesn't talk about rental income. It says income. It says statement of income. Are you saying that 1103 in 2022 didn't make any income?
1103 was the owner of the property, so no, it did not make any income.
Well, how did it pay everything?
I just explained to you,
You borrowed money from every other entity you have.
I have several other businesses, so I would put a check from another company to loan that company to pay whatever bills, taxes, or anything like that. In that essence, that's what I did.
So it's your testimony that every one of the expenses for the business, no, it's not for the business community, every one of the expenses for the land owner, taxes, utilities, you had to borrow money from your other companies because no income was received by your land corporation.
That's correct, because I did not pay myself any rent from Route 35 Associates to 1103.
And, no, just let me finish, please.
Oh, sorry, I thought you were.
That's all right. Let's turn to 23 then, if we could, okay, Mr. Anthony, excuse me. Anthony, you have it there?
Yes, I'm looking at it here, 2023, and under the comments where it says property is owner occupied.
Right. And do you have Schedule A, the third page?
I do.
All right, what does this show as the income, if any, on Schedule A for the land company, which was 1103 Lawrence Harbor?
Again, it's not showing any income.
Okay, so in 2022 and in 2023, your testimony under oath is that this company made the land company, no income and had to borrow money from your other entities to pay all the land-related expenses. Is that your testimony? Sir, what did Mr. Brodsky just hand you in writing? What did he just give you?
I was covering up this.
No, yeah, Mr. Brodsky, please, he's not your client.
And this, I'm saying.
The record should reflect that you wrote something on a piece of yellow paper and gave it to him.
Yes, I mean, I was trying to ask a question, and I was just telling him that I think what may be being asked about is the income from the operation of the.
Mr.
Adult
Brodsky,
club.
we've been doing this too long. There's no need for you to tell him what he thinks, what you think I meant, because he knows what I meant.
Yeah, correct. So maybe I'm a little confused, but
Oh, okay.
Yeah. So
My te- I'm sorry.
1103 Lawrence Harbor Corp. from 2022, 2023. My accounts didn't file yet for 24. Will show the same thing. It's going to show property is owner occupied, and that it made zero money just on the land side.
Made no income.
No income on the land side.
And you understand that when one determines the assessed value of a property, it's on a tax bill, right? You get a tax
And
bill.
that's what you're saying to me.
All right, and the tax bill is made payable to the owner of the land, not the business, correct?
It's being, as the landowner, yes.
Okay, so in 2022 and in 2023, you received the normal tax bill like we all do, and it was payable to the 1103, which is the landowner. And you had to borrow money from other entities because no income was received by that landowner for 2.5 years. None, right?
So are you saying that that I did something wrong and illegal, that I took money from another corporation, that I made money and loaned it into 1103 to pay those bills?
I'm surprised you would even say that. Why would that come into your mind? I never
Well,
said that.
I'm just trying to understand the basis that you're making of 1103 and it's showing zero income when the business of Route 35 was in there making money and showed income. So I'm not sure. So if my accountants made a mistake and should have, you're saying pick up Route 35's income and put it on 1103, I don't think that's the right way of doing it. I have to ask them, but I don't know that. I'm not a professional accountant. I could just tell you that I was open for business.
Okay. And I wasn't in any way saying you did something illegal. I think I'm questioning the testimony that this poor land corporation made no money, to no income, not a little bit, none, for 2 or 3 years, and had to borrow money from your other companies to keep the doors open. That's your testimony, right?
No, it's not to keep my doors open, no.
To keep the
No,
business.
it was just to pay the property taxes or whatever it was that's showing at that time.
Okay.
All my bills that I made from Route 35 as far as keeping the business open came from Route 35 from my checks.
Sir, I never meant to infer to you that I think you did something illegal. I never said that. I think that, in my opinion, and this is for the board, there's some credibility issues when you fill out forms showing, or supposed to show what your income is, so that the assessor can determine what your property is worth. And you say, this property owner didn't make any income for 2.5 years. That's a little.
But my accountants did fill that out accurately, though. That was filled out accurately, that there was no income on that. So they filled that out accurately.
And you're saying, was there a lease agreement between the landowner and the business owner?
No, there was no lease agreement.
Well, what right did the business owner have to be there?
I was the owner. I was the owner of the property, and I ran the business.
Which company owned the liquor license?
Route 35 Associates, LLC.
So the landowner also owned the liquor license.
That's not true.
Excuse me, I'm sorry, isn't 1103?
1103 did not own the liquor license.
Oh, I thought you were just said, excuse me, I'm sorry, who owned the liquor license?
I'm on the liquor license. Route 35 is the owner of the liquor license.
I apologize, I thought you said 1103. Yeah, I thought, okay. So the
Route 35 Associates is the owner of the liquor license. And 1103 Lawrence Harbor Corp. is the owner of the property.
Okay,
Sorry if I said that backwards.
it's okay, sure. Sweet, thanks, that's all I have, thank you very much.
We've gone well beyond our time. That was allotting to people, and I apologize to the other applicants, but I'm not going to have Mr. Hollihan respond tonight, but I'm curious. I didn't get to read this either. I briefly skimmed it a half hour before I got here, and I see there's a lot of checks in here. Do you pay for your liquor through FinTech, or do you write checks?
I write checks.
Okay. Do you have any of them and the receipts for the liquor that you bought during those 2 years?
Yes, I do.
That would probably be helpful, Counselor. Sure. Now, they would be with the address of that establishment, not any of your other establishments.
They would say 1103, which is the address for
Yes.
where the bar's located. Yes.
Okay, that'd be great. I think that would be helpful to see that you were buying beer, you were buying liquor, and it was being obviously consumed, whether you were buying it for there or not. But I'd be interested in that if we could get that. Absolutely. All right, Dan, I'm going to hold off on having you respond to anything, if that's okay.
absolutely.
And I literally have to open this to a public portion as well, because we did have testimony tonight. So I just ask you to sit tight. You don't have anything else you want to say right now, do you, Counselor?
No, I think it's a natural breaking point based on the timing.
Yeah, and we can obviously get back to this,
Yeah.
but.
Yep.
And
Mr. Spilero will be back.
I appreciate Mr. Spilero's comments and his candidness, and Counselor, I appreciate you being here to help him out. Yeah, and as I said, if we can get some receipts that that there was liquor delivered during those 2 years, and I'm sure you still have those, that would be quite helpful. Now I'm going to open a public portion on this matter. This is 1103 Route 35 LLC. Is there anyone here in the room this evening that wants to be heard on this matter?
Mr. Chair, is this for questioning or?
Yeah, whatever they have as far as this witness.
Right,
Yeah,
exactly.
Yeah. Does anyone have any comments? Please raise your hand or stand. Okay, I see none, so I'm going to close the public portion for this evening. If you're here on this matter, but you don't have questions, this matter is going to be continued because we haven't made a determination. The board hasn't acted on anything. So we'll get a new date, Ms. Porcelli? I know we're far out.
The next available open meeting would be September 4th.
September 4th? Okay. Counselors? Is that okay with both of you?
My birthday, but yes.
I'll bring a cake, all right? That's good?
Mr. Brodsky, your client agrees to toll the time period they knew which you have to make a decision.
Of course.
Okay, fine, thank you.
Anything else legally we have to do here? other
Just
than-
announce
I'm just going to
formally
announce
it's-
that this matter will be continued. It'll be on the agenda for September 4th, 2025 meeting. Thank you, counselors.
Thank you,
and
Mr. Chair,
Mr.
members of the
Scalera.
board.
Thank you.
Angela, you're going to be on the next one, right? Okay. You don't need a break. All right? Okay. We're going to move forward. Deanna, you're staying right there, right? Okay, but you're free to walk around should you desire. I'm going to call the next matter in. It's the 12-2024Z Reformed Church Ministries. This is EDO 3 Zone, Block 17000, Lot 27.11. Major preliminary and final site plan with D variance. Applicant proposes a 700 square foot building addition renovation to the existing staff lounge as well as courtyard improvements. Counselor? Mr. Pape?
Good evening, Mr. Chair, board members, board professionals. My name is Jared Pape, attorney with the firm of Heilbrunn Pape, filling in for my colleague Peter Klauser, who's the attorney of record for this application. Our office represents the Reformed Church home. Before we begin, I'd like to ask the board to confirm that the notices that we provided were satisfactory to provide this board with jurisdiction.
I'm told they have been.
Yes.
Yeah, we take jurisdictions, right?
Thank you. This is an application for preliminary and final major site plan approval with use variance relief. The facility on site is an existing senior living facility that offers assisted living and skilled nursing. They've operated continuously at this site since 1998. It is an existing non-conforming use. There's limited proposed improvements, which consist of an approximately 700 square foot staff lounge and some courtyard upgrades. You'll hear in testimony tonight that these improvements, we believe, have little to no impact, no detrimental impact to the public, and will overall enhance the site so that they can continue providing a high-quality senior living environment for both the residents and staff. We have 4 witnesses. First up is Mark, and I'm not going to pronounce your last name because I'll butcher it. But if there's not any questions or comments at this time, we'd like to move to our engineer.
Would you, sir, do you swear or affirm to tell the whole truth, so help you God?
I do.
And give us your full name and spell your last.
Yes. Name is Mark Januszewski. That is Janiszeweski.
Is that V-E-W, like Victor?
Zew. Z as in zebra. Zeweski.
And your first name is, I'm sorry, sir.
Mark, M-A-R-K.
That was not hard.
And Mark is completely acceptable.
I'll ask for you to provide your professional credentials for the board so you can testify as a professional engineer.
Yes, I have a degree from Lehigh University in civil engineering. I have currently work for Collier's Engineering and Design, formerly Maser Consulting. I have been with the firm for 21 years. I am a licensed professional engineer in the state of New Jersey, and I've been licensed since 2005.
We'll certainly accept your credentials and expertise.
Thank you.
Mark, I know your office prepared some exhibits. Perhaps we could pull up those exhibits and mark them.
Yeah, aerial exhibit, please, Mr. Pacelli.
And I'll pass it off to you and ask you to go through the existing conditions and proposed improvements. I know we have a review letter as well that we need to touch upon.
Yes. No problem. Thank you. As it's coming up, I will just state, as I know it's on the record, it is lot 27.11 in block 17000. And the exhibit that we're going to be pulling up is an aerial view of the site from Google Earth. We've dated this plan June 4th, 2025. And the plan, as you can see here, and I'll highlight the property. This is the Reformed Church located on the I'll call the northbound side, maybe it's the westbound side of Route 18. And this is approximately a little bit over a 12-acre property with the one building for the Reformed Church home. As stated, the Reformed Church home is an existing long-term care and assisted living facility. The home was constructed in 1998. The property, as I mentioned, lot 27.11 in block 17000. The site is accessed via a single driveway from Route 18. There's a single driveway that comes in on the southern portion of the site. The driveway then proceeds all the way around to the back of the building. At the front of the building is a car parking lot. I will note that in around 2020, there was an approval for an expansion of the parking lot, and that parking lot expansion was constructed late 2021, early 2022. That was the last time we believe that the home was in front of this board. Also on the property, essentially on the northwest side, is a stormwater detention basin. This is a surface basin that handles all the stormwater management for the property. The building itself, you can see, is generally orientated parallel to Route 18. There are pieces of it that do go to the back as well as going to the front, but it is one uniform building. The site is located within the township's EDO3 zone, the Economic Development Opportunity District, in which retirement homes and assisted living facilities are not a permitted use. Therefore, we're here for site plan as well as use variance for the expansion of a non-conforming use. This site plan application is for an approximate 650 square foot addition to the building, as well as courtyard improvements. All work for the addition and the courtyard improvements are located at the rear of the site. The addition will be located at the interior northwest courtyard, and there will also be improvements to the northeast courtyard. And I'll note that, again, following the driveway around, the driveway goes to the back of the building. There's a courtyard right in this location. That is where the addition to the building will be, and as well as courtyard improvements. And then there's an existing piece of building right here. On the other side of that building is another courtyard area that we are also proposing improvements. With that, Ms. Pacelli, if we wouldn't mind going to the site plan rendering. It's the rendering. So, yeah, do you have the one that's the rendering? Thank you. I know we gave you a lot of files, so that's my apologies. I always like to come extra prepared. As she pulls it up, I will note that what is being pulled up, and you'll see momentarily, is a rendering of the overall dimension plan that was submitted with the application. It's essentially the dimension plan, layout plan for the property with some color added to it, just to, so you can see the differences between the existing and proposed developments. This rendering is also dated June 4th, 2025. Perfect, thank you. So here for orientation purposes, north is up at the top of the screen here. So same thing, Route 18 is along the bottom on a diagonal here. The driveway that I've mentioned several times is this driveway that goes all the way in the back. Parking lot in the front, the expanded parking lot that was built in 2022 is here. So on this rendering, the dark gray is the existing building. So you can see the existing building, like I said, essentially parallel to Route 18 with pieces that do stick out. The addition is this brown color right here. It kind of blends in a little bit with the landscaping and courtyard improvements, and the additional other courtyard improvements are located here. So you can see none of these improvements will be visible from the street. They are essentially screened by the existing building themselves. This addition is, the interior of it is for a staff lounge. It gives the staff more space to spread out. We have the executive director, administrator here that will provide some more testimony on that. But this addition does not add additional beds. It does not add additional employees. It is really just to provide more space for the workers currently at the site. So because of that, there will be no change to traffic counts at the site.
How big is the existing facility without the improvements?
I would have to check that.
All right.
Back to you on that. So with the courtyard improvements, I'll just kind of name some of the improvements that are being done. There's new walkways, benches, a pergola, a small shed, as well as new trees and shrubs and other architectural landscape amenities within it. With regard to stormwater management, there is a minor increase of approximately 0.1 acres of impervious surface. Translating that to square feet, it's approximately 4,350 square feet of impervious coverage that is being added as part of this proposed plan. Since the application does not propose more than a quarter acre of impervious, nor does it disturb more than an overall acre of disturbance, the project is not subject to the state stormwater management rule nor the stormwater management rule for Old Bridge Township. There is only approximately 0.3 acres of disturbance. We have received approval from the Freehold Soil Conservation District for this project, so we're on our way in a good direction. Runoff from the proposed improvements, and I'm touching upon this because it's in the in your professional's review letter, is captured by the existing stormwater management measures on site, inlets, storm pipes, and all of it is collected and directed to the existing stormwater basin at the northwest portion of the site. Because of a de minimis increase in impervious surfaces, there is really no significant impact to the overall stormwater runoff rates and no significant increase to any stormwater volumes with it. It's really just minor expansion of impervious that really won't have an impact, and the runoff is being detained in the basin. I will note that, as was designed by our landscape architects, some of the impervious that's actually going in is porous asphalt, porous pavement. So that will actually also help mitigate any increase in the impervious surfaces. The porous allows for the runoff to infiltrate directly into the soil, thus slowing the time it may take to get to the overall detention basin and off-site. I will note that there was a comment in your professional's letter about the porous asphalt. These were really just done as literally just a green type of design to incorporate it, helping the trees, helping the shrubs, trying not to have so much asphalt and everything in there and open things up. So these were not, because they were not needed for the stormwater management regulations, they weren't designed in strict conformance with the NJDEP Best Management Practices Manual. They didn't need to be. They're just there as extra green features on it. I bring this up because there was a comment to provide test pits to determine permeability, to determine seasonal high groundwater. Would request not to do that because asphalt is not required to meet those requirements. We're really just providing it as an enhancement to the site itself. There was also a comment from your professional about the existing stormwater facility itself. I was just at the site today, looking at the basin. Everything appears to be functioning correctly. I didn't see any evidence of basin failure. Also looked around some of the inlets. They seem to be working in good condition. There was a comment to clean and televise those lines. Would prefer not to have to go through that expense, as we feel everything is functioning as it should be. And again, just kind of summarizing here, small increase in changing of impervious surfaces. We've taken a few trees down, adding a lot more landscaping that will be touched upon. No change in traffic patterns for the site. And because there's no change in traffic, we don't need DOT approval for these improvements. And that's all my direct testimony there.
And one, Mark, you mentioned this, but just to reiterate the point, there's a minor addition, but there's no increase in the beds or a residence, correct?
That's correct.
So, and all of the improvements are limited to the rear of the site. And as you mentioned, there's no anticipated traffic increase associated with any of those improvements.
That's correct.
Mark is available if there's any questions from the board members or professionals.
Thank you. Mr. Dargy?
Good evening. Thank you, Mr. Chairman. Our memo is dated June 3rd, 2025. The applicant's witnesses provided quite a bit of the testimony that we did request in our memo. For the most part, on this application itself, on the whole, is sort of a minor kind of application. But where I do have to disagree is regarding the stormwater. The representation that this is a minor application, I think it doesn't take into account that the prior site plan had a fairly large parking lot expansion. Were you involved in that site plan at that time?
I was not.
Do you have any information at all about that site plan?
I know that it was approved around 2020 and constructed in end of 21, beginning of 22 is
Right.
my knowledge of it.
So it appears, and again, you can scale it, but it appears that the prior application was a major project from a stormwater perspective, right? You could.
I would.
It looks like it's more than a quarter
I'm
acre.
assuming it's more than a quarter acre,
Yeah.
so I'm assuming that application was compliant with the stormwater regulation. at
Right.
that
So
time.
so then, what we're required to do, and where the township has the way that we approach it, is that we as the township have a stormwater general permit that the township is required to maintain with the DEP, and one of the many requirements of that stormwater general permit is that the township has, through its boards, the planning board and the zoning board, is required to make developers comply with the NJC 7:8, the DEP stormwater standards. That's what our ordinance says. One of the things that requires is that you actually aggregate the impervious coverage and disturbance and all that. So this project, though it's a minor project, isn't really a minor project because you had a 2020 project, which was a major project. So in essence, even though you didn't file this as an amended site plan, that's sort of the way that it has to be looked at least from a stormwater management perspective. So you really have to do an analysis of the 2020 application and say, with this addition, with this alteration, whatever you want to call it, does it still comply with the stormwater management requirements? So there's none of that in the stormwater management report. The stormwater management report simply says, and I agree with you, maybe 20, 25 years ago, we could just do a rational method and say, 4,000 square feet of grass turning into impervious, no big deal. We can't do that. So we really need an analysis that shows that it complies with the stormwater management requirements. Same thing with regard to the operation and maintenance, right? We need to ensure that the existing system is functioning properly. Whatever the operation and maintenance requirements are currently on the property have to be updated to incorporate, the porous pavement, and also has to be updated to require maintenance and inspection. Because again, that's another thing that the township is required or obligated to do under its stormwater management general permit is require private landowners of stormwater management systems to maintain those systems. So as part of this type of approval, we have to make sure that that's being done.
Yes, and with the maintenance, the requirement to provide an stormwater operations and maintenance manual has been a regulation of the DEP since 2004. So I haven't checked the records, but I'm assuming there is an operation and maintenance manual that probably had to have been filed for the 2020 application for the existing parking lot. We'll ensure that it is there, and yeah, we will agree to update that manual with it. I personally don't think it's necessary because they're not BMPs that are required, but I understand your point, and we'll agree to update that manual. And if you do want additional analysis of the additional 4,300 square feet impact on the basin, we will do that. It's a bit cumbersome, I will note, for such small improvements, because I have to assume that the parking lot was in compliance at the time. Otherwise, I don't believe this board would have approved it. So in my opinion, I think that basin was designed for the additional parking, and obviously this is just a de minimis increase, which our calculations will show.
Yeah, we'll need an overall analysis of the actual basin, right? We can't have a rational method analysis saying it's 4,000 square feet, no big deal. It's unfortunately, we just can't do that, right? The township's requirement is that we have to make sure it complies with the NJC 7:8 because we have a stormwater general permit. I've been involved in quite a few municipalities where the DEP does audit, right? We've had Voorhees, Cherry Hill, a couple other towns that where I'm involved, where DEP actually audited the board, and at that point, with all due respect to the applicant and applicants all over, the applicants are pretty much done at that point. They're not on the hook. It's actually the township that has to sort of answer for the approvals that they granted, right? So for that reason, we can't just say it's no big deal. So should the board act favorably, I would recommend that the approval be conditioned on an analysis that shows that the site is compliant with NJC 7:8.
Yeah, I do want to note that as an engineer, you'll understand adding additional impervious, changing from lawn to impervious, will have a slight increase in runoff rate out of that basin.
That's why we do the analysis, yes.
And our opinion is that because it is, the prior application was approved and done, and I understand the cumulative nature of it, this application will have that de minimis increase. I don't believe we're required to then meet any additional flow reductions.
You are. You're required to show that the reductions are still in. So and this is why I always say to Jim, you don't want me to get into the stormwater stuff in the meetings, but I guess I have to today. What you really have to do is go back to your stormwater report from 2020. You have to dig it up, and what were the allowable rates at that time? What does it do when you, and I'm not so stringent that we're saying that, hey, you have to reduce this 4,000 square feet. What I'm saying is you have to go back to it and look at it as an amended site plan. Go back to your stormwater report. What was done back in 2020? And instead of the proposed condition being just the expansion, now the proposed condition will be the expansion and what you're proposing now. And what does that do for your rates? And you're probably going to find that you're okay if the design had any slack whatsoever, which I'm hoping it did, right? Neither one of us were involved with that. Yep. But a good engineer's design with some sort of slack. So I'm hoping that was the case, and you'll probably be okay. But we need that analysis.
Okay, we agree to comply.
Mr. Dargy, would this be something that you can do administratively, or do you want the board to hear this testimony live to base a decision?
I believe that what we're talking about is very technical in nature. So I don't think that my understanding or my gut feeling is that it's not going to change the design. It's not going to change what you're seeing. But we have to have the backup paperwork so that Ms. Shapiro doesn't get in trouble when the DEP comes down.
No, I fully understand.
So if your question is,
if you're, I'm saying, do you want us to delay making a decision tonight on this matter, or conditionally a decision?
I'm
if
comfortable.
we should approve.
Yeah, I'm comfortable and I know exactly what you're asking, Mr. Chairman. I'm comfortable if the board were to approve the application with the condition that the applicant submit an analysis demonstrating compliance. Well, and and I see Ms. Chevalier shaking her head a little bit, so let me just say, as with any condition, if the applicant does not comply, or if there's any significant change whatsoever in the site, it would require an amended site plan. So they'd have to come back.
Counselor, you,
I knew that's what you were getting at.
That's acceptable. That's
Okay.
acceptable. Yep.
Ms. Scheffler, did you?
No, that was it.
Okay. Mr. Dargy reads our minds well.
Other than that, Mr. Chairman,
As
I
long
don't
as
have any.
that's, agreeable with the applicant?
Yes, it is.
Okay. Anything else, Mr. Dargy?
That was the only item that I really wanted to bring to the board's attention and to the applicant's attention. I don't have any, let me just, give me 1 second, Mr. Chairman.
I see the tree removal plan. Is that,
We'll agree to comply with that comment.
That was going to be, I guess my question is, other than this, what we just spoke of, is there anything in our memo that gave you any heartburn?
No, it was really just the stormwater that I mentioned.
I
there,
figured it was
and the traffic that I mentioned, that there's no change in traffic, so we don't want to propose doing any additional traffic counts or analysis.
is that okay with you?
And I would concur with the traffic portion. The applicant is really just adding an employee amenity. They're not going to, we asked for testimony in our memo as to whether there was any kind of increase in staffing. They're not proposing any increase in beds, so from both
employees.
standpoints, there's no increase in traffic. So I would concur with the applicant's assertion there. And of course, I'm happy to answer any questions the board may have, but I don't have any other additional questions for this witness.
They've satisfied your memo, to your satisfaction, they've responded.
Yes.
With the exception of the stormwater.
With the exception of stormwater, which the applicant did agree to. Do you have a planning witness?
We do have a planning witness that will provide with regard to the non-conforming.
Because I'm playing
extension of a
the role of Ms. Sawant.
Gonna
this
be
evening as well.
chats? Okay.
Yep.
Let me see if any of the board members have questions on my left of this applicant, of the engineer. None? On my right? Counselor?
No, sir.
Mr. Pape, we're back to you.
Thank you, Chairman. Thank you, Engineer.
Our next
Mr.
witness
Genesee.
is Kate Shepard, who's the Executive Director of the Reformed Church Home. I'll ask her to come forward.
I think she is.
Could you please raise your right hand? Do you swear or affirm to tell the whole truth, so help you God? Can you give us your full name and spell your last?
K-A-T-E, last name is Shepard, S-H-E-P-A-R-D.
Thank you.
Could you identify your role and position with the organization?
You can slide that over. Yeah, they're directional, the microphone, so yeah, perfect.
All right,
Thanks.
I'm the Executive Director of the Reformed Church Home.
Thank you. I've asked Ms. Shepard just to provide some operational testimony, the existing operations as well as the reason for the proposed improvements. So if you could take it away.
So this, our improvements were really as a direct response to the pandemic. Just for all you, nothing has changed from 2020 from our world. We are senior living. We do have to abide by the state. We still have masks. We still, like you walk in, it's a lot like 2020. In response to that, the 6 feet, the differencing has gone away a little bit, but we originally started this project in response to that. So the break room really used to be the more the merrier, around the table, come up, join a seat. The nurses now, nobody's as comfortable as they were, and the business has changed, and how we operate has changed since then. So the idea of putting 6 and 8 people at the same table during break time is not acceptable for the state of New Jersey's health standards, but also a comfort level of our staff. So that's really why we were looking to increase that break room size, to give people just a little more space, that we're not just pulling up multiple chairs because things have changed. In the courtyards, the plan the idea was to, the way the courtyards are established is to provide some privacy. A lot people, when they come to visit, whether the mask requirement is too much, whether they don't want to be in the facility and be reminded of COVID. A lot of people are choosing to visit outside with their loved ones. We have wonderful grounds, a lot of nice places to sit. But again, the courtyard was to say, rather than have like one long strip where people would be next to each other, was to have more meandering areas where maybe one family could be over here. There'd be plantings and things to separate if multiple people wanted to be outside during visitation. So that's really why the improvements we were asking for.
And just to confirm, so the improvements are really meant to be an amenity to the staff, the residents, and their guests. And there's no, as previously stated, there's no increase in the bed count, there's no anticipated increase with the staffing as a result of these
As a
improvements.
result of the changes, no. It was really in response. It started out as the residents, again, during 2020, everything was outdoors in the courtyards. And we were saying that it would have been nice had we had more areas. So we were trying to develop these areas with some privacy so families could see. And then we naturally started looking and saying we should have trees and plantings and things that would do that natural separation. And then while we were at it, then we added the break room on, saying, well, the nurses are saying the same thing, that they would like a little more space. So it really, everything's in direct response to how the business has changed since the pandemic.
I have nothing further. Ms. Shepherd, if there's any questions.
Mr. Dargy, anything from,
I have nothing, Mr. Chairman.
No, sir.
on my left? No. On my right? You know, I will say, I have a friend whose mother lived there. I know you do great work there. You provide great care for the residents. So I hope you continue to keep that high level of standard. I've heard great work, great words about your property. Thank you for appearing.
We have two more witnesses, but we'll be very quick, knowing
Sure.
that we're up against the clock. I'll have Richard Quinn, our architect, step forward.
Sir, would you raise your right hand? Do you swear or affirm to tell the whole truth and nothing but the truth? I do. Would you give us your full name, spell your last?
Richard Quinn, Quinn.
Thank you.
Mr. Quinn, could you provide your professional credentials for the board and your involvement with this project?
Sure. I'm a graduate of Drexel University. I've been a licensed architect for the past 20 years. Registered in 7 states, including New Jersey. Principal with Spiesel Architectural Group. We're headquartered in Hamilton, New Jersey. I'm a principal with the firm. I've worked in conjunction with my partner, who was the project lead on this project, who is unfortunately out of state. So I'm standing in for him as the project lead.
That's Steve Leone?
That's Steve Leone, correct.
Thank you. We're certainly
Hopefully
going to
that doesn't
accept
hurt
your
my
credentials, and thank you for putting that on. People watch at home, and sometimes they see witnesses, and if we don't explain who they are or what they do, it's confusing. So thank you for doing that.
Sure.
I know we're pulling up some exhibits. We have this appears to be the floor plan. Are there any other exhibits you would like to pull up for your testimony? Or okay.
This will suffice.
Okay. Well, Mr. Quinn, I'll ask you to just describe the exhibit that's up on the screen and the design that went into this addition.
Yes. Which button's the pointer? Which button's the pointer? Can I just try?
You can swap that one out.
Oh, I got it. There we go.
There we go. We got it.
Okay, this is the line of the existing building, the existing staff break room. So our addition, our 700 square foot addition, is this space to the south of that existing. So as you can see, we're opening up that existing wall to connect the two spaces. The space has been laid out with sensitivity to the existing resident apartments nearby, which is the reason for the angled wall. This is where the majority of the glass resides. So when someone's inside, their focus is out of the break room at an angle to the courtyard space, which you had seen previously, puts all the focus in the center instead of looking directly into resident rooms. This corner of the building here that's carved away still maintains a roof. So the staff, as Ms. Shepherd had mentioned, can flow both inside and out of the building. So they can be out in the courtyard space or under the covered space of this roof or within the break room.
Thank you. I have nothing further. If there's any
Mr. Dargy?
questions.
I have nothing, Mr. Chairman.
Board members on my left? Anyone? And on my right?
No.
Counselor?
No, sir.
Go ahead, Mr. Pape.
Thank you very much.
Thank you, Mr. Quinn.
Our final witness is Julia Mooser, who I may have also butchered that name, is our professional planner. Ask that she be, how'd I do?
Hello. Would you
Okay,
please
yeah.
raise your right hand before you, do you swear or affirm to tell the whole truth and nothing but the truth? Give us your full name, spell your last, please.
Julia Muser. My last name is M as in mom, U-E-S as in Sam, E-R.
Thank you.
You could please provide your professional credentials for the board.
Sure. I have a landscape architecture degree from Penn State. I've had my landscape architecture license in 3 states for approximately 25 to 30 years. I have a professional planner's license in the state of New Jersey, and I've had that for between 6 and 7 years, and I do have experience providing testimony.
Thank you. We'll accept your credentials.
Thank you. And as mentioned, we are requesting D2 variance relief for expansion of a non-conforming use. So I'll ask that you describe your process in reviewing this application and developing the justifications for the planning test, the variances.
Sure. I have reviewed the site plans, the zoning ordinance, and the master plan, and I would like to provide planning testimony in support of a D2 use variance to allow for a small addition to the existing nursing home, which is a lawful pre-existing non-conforming use in this zoning district. As the board is aware, the standard for a D2 variance is whether the proposed expansion can satisfy the positive and negative criteria under the municipal land use law. In terms of the positive criteria, the proposed addition advances several purposes of zoning under D2. Purpose A, to promote the general welfare. The continued operation and modest expansion of this nursing home directly serves the public interest by providing needed health care and housing services for elderly and medically fragile residents. The addition will improve the facility's functionality and care capacity without introducing a new or incompatible use. Purpose G, to provide sufficient space in appropriate locations for a variety of uses. This facility has been successfully operating on the site for many years. The proposed addition is modest in scale and is being constructed on land that is already associated with the use. The site remains suitable for the continued and slightly expanded use due to its existing infrastructure, access, and buffering from surrounding properties. Purpose I, to promote a desirable visual environment through good civic design. The architectural and site design of the addition is consistent with the existing structure and will not alter the neighborhood character. Landscaping and buffering are being maintained and improved, and no negative visual impacts are anticipated. The proposed addition does not alter the essential character of the existing use, but rather enhances it to better meet modern standards and the needs of current residents. Because the site has long been used for this purpose and is uniquely suited for its continuation, the positive criteria for the use variance are satisfied because the use is a lawfully pre-existing, non-conforming use. With respect to the negative criteria, the board must determine whether the proposed addition will result in a substantial detriment to the public good or a substantial impairment of the intent and purpose of the zoning ordinance and master plan. The proposed addition satisfies both prongs of the negative criteria. No substantial detriment to the public good. The proposed expansion is modest in scale and fully integrated into the existing nursing home operations. It will not create new traffic patterns, introduce new uses, or generate adverse noise, light, or visual impacts on neighboring properties. The site is large enough to accommodate the addition without reducing setbacks or open space in a way that would affect adjacent landowners. Furthermore, the nursing home has long operated at this location without incident, and the proposed improvements will enhance the safety, accessibility, and functionality for its residents and staff. Therefore, the public good is not only protected, but is arguably served by this improvement. Number 2, no substantial impairment to the intent and purpose of the zone plan and zoning ordinance. While the nursing home use is not permitted in the zone as of right, this facility has lawfully existed here for many years as a non-conforming use. The proposed addition does not intensify the use in a way that undermines the zoning ordinance, nor does it encourage a pattern of land use contrary to the district's intent. The proposal maintains compliance with bulk standards, and it does not encroach on neighboring zones or uses. It is a logical and limited extension of an established use that does not set a precedent for unrelated commercial or institutional expansion in the area. The proposal does not undermine the municipality's master plan goals and in fact supports planning objectives related to senior care and health services. For all these reasons, it is my professional opinion that the proposed addition satisfies the negative criteria as required under the municipal land use law.
Thank you. Ms. Muser is available for any questions from board members or professionals.
Mr. Dargy with the new hat.
Thank you, Mr. Chairman. The applicant's planner provided the testimony that we'd requested in our review memo. Essentially, it's a D2 use variance for expansion of an existing non-conforming use. The criteria here is really just, you don't have to concentrate more on the positive criteria because that's the use is existing. It's really more the negative criteria, which is does the use pose any detriment to the zone plan and the public good, or is there any substantial detriment to the public good? And essentially, what you have here is as simple as it gets. There's no actual intensity increase here. What the applicant's doing is just proposing an expansion for an employee lounge for existing employees and improvements for to the courtyards, which are aesthetic improvements, and again, don't pose any detriment to the public good. So I think the applicant has provided the testimony that we had requested, and I'm happy to answer any questions the board may have.
Thank you, Mr. Dargy. Board members on my left? No. On my right? Counselor?
No, sir.
I probably wouldn't notice the change when this was done, right, if I came onto the property?
That's correct.
Are you altering this in any way? Is anyone going to be upset over this build off of your lot?
No, you're not even going to be able to see it from the outside.
That's kind of what I thought. Okay, thank you very much. You have anything else, Mr. Pape? Any other witnesses?
No more witnesses, no.
Okay. Let me go to a public portion quick, and we'll come right back. This is matter 12-2024Z. This is Reformed Church Ministries looking to put an expansion on for employee lounge, I assume, and some courtyard improvements for those who may be visiting their loved ones there. Anyone in the room here wish to be heard on this matter, please raise your hand or stand. I see none. I'm going to close the public portion. As I said before, I've heard great things about this property personally. So I think you do great work there, and I hope you continue to do so. And this is an existing condition. You're already there. You're in full operation. And I think that certainly your staff probably deserves a little bit more room to have a little bit better flow and maybe feel a little bit better about themselves while they're working. And certainly those that are visiting, as Ms. Shepherd said, some people, choose to be outside. So I think that's a great thing for all, and helps everybody probably physically and mentally. So I'm going to support this. We'll see if the board has any other final comments or questions.
No questions.
None? None, Mr. Stoner? Vice Chair? And Counsel, you have nothing?
No, sir.
We do have 6 to vote. Are you comfortable with asking for a vote on the D2? There's no bulks at all, right?
No.
Okay. So it's just the D2.
Out of an abundance of caution, could I have a 2-minute recess
Absolutely.
just to consult
Absolutely you
with my
can.
client?
If you need to, Mr. Pape, by all means.
Thank you. We'll be very quick. Thank you.
All right. We're not going to go off the record, okay? And in the meantime, I hope that the next application, if you have all your things ready, we're going to move right along because I believe we're going to have a change of stenographers, so we will not need to take a break unless the board's going to request one. Okay, all right. Mr. Pape.
We would be comfortable proceeding with a vote.
Yeah, I think that's a good idea. This is for D2. This is expansion of a non-conforming use. Anyone here in favor of moving that for approval?
Testaverde.
Is there a second?
Chevalier will second.
Roll call, please.
Ms. Chevalier?
Yes.
Mr. Scogno?
Yes.
Mr. Stoner?
Yes.
Ms. Testaverde?
Yes.
Ms. Gomez? Chairman Sullivan?
Of course, yes.
Thank you very much.
Thank you, Mr. Pape, and all your witnesses. With the conditions, don't forget, that we have to, that all has to be squared. Okay.
Correct. Thank you.
Thank you, Mr. Pape. All right, we're going to go a quick 5 minutes, so some of the board members just need, but please set up during that time. We stand in recess. All right, we've come back from recess. We're going to start on a new application. Ms. Porcelli, could I have a roll call, please?
Sorry. Ms. Chevalier?
Here.
Mr. Scogno?
Present.
Mr. Stoner?
Yeah.
Ms. Testaverde?
Present.
Ms. Gomez? Chairman Sullivan?
Here. Thank you. When we left for a quick break, we have a new application, 03-2024Z, Elite Marble and Tiles LLC. This is EDO 1 zone. It's block 26020, lot 7.11. Physical locations, Englishtown Road in Old Bridge. This is for a single-family home. The applicant seeking a bifurcated use variance to construct a single-family home, seeking D variance. Mr. Arch?
Yes, good evening,
Counselor?
members of the board professional. My name is Tim Arch. I'm an attorney licensed in the state of New Jersey. Our application is not as salacious as a gentleman's club, and it is not as virtuous as the last. So we're somewhere right in the middle, but we will be mercifully brief, hopefully.
We are quick listeners.
Yes, good. So this lot actually has a little bit of a history. About 2 years ago, we were in front of the planning board with an application for a permitted commercial use on this exact same lot. This is in the EDO 1 zone, which does not permit single-family residences. It's sort of commercial uses. The lot size for the EDO 1, the minimum lot size is 1 acre. Our property is 0.27 acres, so it's significantly under the minimum lot size for that EDO 1 zone. Because of that, putting a commercial use on there has proven to be very, very problematic. One of the issues, and it was brought up, I believe, in the planning report, and was brought up by your professionals or the planning board's professionals 2 years ago, was because of the constraint of the lot, a couple different things really can't occur. Number one, your fire code for new commercial businesses requires that there be circulation around the entirety of the building for firefighting purposes. With a lot that small, it's nearly impossible to get circulation around the entirety of the commercial building that's there. Also, the lot is positioned directly across from Gordon Avenue, and so any sort of traffic would have to go right into where that intersection is, and there was obviously brought up some issues that really any commercial use there, you're going to have some problems with traffic entering right onto where Gordon Avenue makes that crossing. And in addition to that, there's other constraints that are mentioned, which, quite frankly, don't just apply to the use, the commercial use that we were applying for, but really all commercial uses and all the permitted uses in that zone. And so we withdrew that application. And quite frankly, a use that fits much more in line with the size of the lot, and actually, surprisingly enough, with the surrounding properties and the fact that the R6 zone is directly behind our property. We are on the dividing line of the R6 zone and the EDO 1 zone. It's actually, we find, much more suited to be a single-family use. And actually, the properties, there's several properties right next to us that are also what I imagine were pre-existing single-family uses before the EDO 1 zone was put in place, which I believe was in 2015. So we're not asking for any bulk variances, any C variance relief. This is just a use variance, a bifurcated use to allow a single-family home to be constructed on that lot. You will hear testimony from our one witness, Mr. John DuPont, who is both an engineer and a planner, so more than one person doing that dual role tonight. And hopefully that will truncate his testimony a little bit. We have no issues with any of we do have a planning report that we received today. We have no issues with any of the comments in the planning report. I do want to just confirm that we are not seeking any bulk variances. If for some reason in the construction or the design of the home, it turns out that there are variances that are triggered, obviously we would have to come back and we would have to seek relief for that. So we are not seeking any variance relief at this time, aside from the use variance. And we certainly, there was a comment in here that we would have to comply with all the standards of residential properties that your ordinance has. We, of course, agree to do that, to apply to all those residential design standards and other standards. So unless there's any other questions for me preliminarily, I think I'm ready to proceed with my professional.
Mr. Arch, why is it a bifurcated application?
Well, so interestingly enough, residential site plans are exempt from site plan. And so if you were to grant the use variance and we were to then design a home that conformed to your residential standards and that did not require any variance relief, then your professionals can review that, confirm that that is the case, and then we would be exempt from that site plan procedure. Or we can also request a waiver in the I guess, in the purview of your professionals. I did reach out and speak to Ms. Sawant on this matter because it does indicate in here in the report that if this were granted, a site plan application would be required. I think that might be just kind of a carryover for most bifurcated uses.
I spoke to her today. That's correct.
Correct.
Yeah.
And so obviously we will make ourselves available to whatever the appropriate process is when we design the house If it requires a site plan because it requires any sort of relief or any sort of review from the board, we'll certainly comply with that. But if it fits within your exceptions and fits within your waiver process based on your professional's review, we would just ask to be treated like any other residential application that the town would see.
You raise your right. Do you swear or affirm to tell the whole truth and nothing but the truth? Would you give us your full name, spell your last?
My name is John P. DuPont, D-U-P-O-N-T.
Mr. DuPont, if you can please just put some of your credentials on the record, I guess both as an engineer and a planner at this point.
I have a BS in civil engineering from University of Hartford. I am also a certified municipal engineer. I am also a professional planner by examination. I've served for the last 28 years as the Planning and Zoning Board engineer and planner for the Borough of Carteret. I've been throughout the state and numerous boards throughout the state.
Certainly accept his credentials and his expertise.
Thank you.
John, before you begin your testimony, you were involved in all the history of this application. Was my recitation to the board about what we went through with the planning board application, withdrawing it, and now this application, was that all accurate?
Yes, it was.
Okay. So take us away, orient us to the site, and if you can, please just touch upon the justifications for what we're asking for tonight.
Certainly will. So, as you heard, this is block 26020, lot 7.11. It's in the Economic Development Opportunity Zone, the EDO-1 zone. We've put the site plan up on your board. It is just simply the one sheet. The current property is vacant. It's 0.27 acres. The lot existing is 125 by 96 on Englishtown Road near the intersection of Gordon Avenue, as you see on the plan. The proposed project now, as you heard, there was history, but the proposed project now is currently just proposing a single-family dwelling. So there is use required. We need a use variance because in this zone, residential is not permitted, so we will need a use variance. So we'll balance the positive and negative criteria. So as you're aware, again, we did it. We came to the board prior, a small commercial building. There was difficulty with the application because of the smaller lot. We had difficulty with traffic and circulation and your fire access. So the project didn't go forward. We withdrew it, and the applicant has rethought the project. So now we're back with a single-family home, requires the use, but it does fit the surroundings much better than the prior application, quite frankly. And we will go in a minute, not yet, but we'll go in a minute to an aerial, and I'll show you the surrounding properties. So, matter of fact, I guess we should go to it now. I got the other one. Let's do that one now because I want to show the three. So this is an aerial exhibit. Yep. And what you're going to see our property in the middle. I believe it's in. Do you have it like in red?
If you can just maybe zoom out a little bit so that we can just see the entirety of the thing. I think that's a little zoomed in.
Do you have a pointer by any chance so the
I don't.
board can?
Do you have?
Yeah. Thanks. You can just highlight that for the board?
If you could just, if you can just scroll down slightly so that our property is in the center. It's right there, perpendicular to Gordon Ave, or across from Gordon Ave.
There you go. So the Gordon Avenue, that's the intersection of Englishtown Road and Gordon Avenue. The wooded lot that is actually our property. If you look at both, there's three adjoining properties. There's one to the top of the page, there's one to the rear, and there's one to the bottom of the page. Two out of the three are residential currently. That's a residential property. The one in the rear is the exact mirror image of our property, residential. And the one up top is a JD wood flooring company, but it's a dwelling. They have a business in the back, but it looks just like a home. So when we look at the area, the proposed single-family dwelling really matches. We look up and down the street, as you can see, on Englishtown Road, residential, residential. To the north, to the top of the page, there are a couple businesses. But to the bottom of the page and the entire back, all these lots in the rear are residential. Now, what Mr. Arch said was accurate. We are in the EDO-1 zone, but the back of our property line is the dividing line for the R6 zone. So, in essence, we're surrounded by residential properties. So we certainly will meet the characteristics of the neighborhood. We could certainly build a single-family home with no variances. We can meet all your bulk requirements. And we feel very clearly that several purposes of the MLUL will be advanced by this project. Purpose A, we're encouraging appropriate use and land and development of lands. We're providing light, air, and open space by meeting all your bulk standards. We're promoting appropriate population densities. Again, single-family home in an area, same character. We're providing sufficient space for location in a variety of uses, not overbuilding. And we're promoting a desirable visual impact. So we're taking a wooded lot and going to build a new single-family home. Certainly, improving the housing stock, fitting in their neighborhood for sure. As far as negative criteria, I see no substantial detriment to the public good. We have an applicant that has attempted to meet the EDO standards, was unsuccessful, has rethought his project, has come back to the board. There was restrictions on the first application. The lot size really did restrict the project. This lot is a lot smaller than what's minimum for the area. So a residential single-family house on 125 by 96-foot lot makes a lot of sense. The lot can support it. It's no problem. We meet all the bulk setbacks. The benefits of the project, as we talked about, will clearly outweigh any detriments. Granting the variance will certainly not substantially impair the intent or purpose of your zoning plan or your master plan. It's a project that came here. We heard from the board. We have guidance. We heard from your professional staff. We went back to the drawing board. Applicant rethought it, proposed something that fits the character of the neighborhood, going to provide new housing stock. I think it's a terrific project. We will clearly meet all your bulk requirements for the single-family home, and the only variance we need is the use be in the EDO zone. And that completes my testimony.
Thank you. Mr. DuPont's available for questions.
Thank you, Counselor. Mr. Dargy?
Thank you, Mr. Chairman. Ms. Shapiro and Ms. Sawant's memo is dated June 5th. The applicant has provided the testimony or the proofs that Ms. Savant has noted for use variance. And I also had a chance to discuss the application in detail with Ms. Savant yesterday and this morning. And I can corroborate what the applicant and Mr. Dasty said earlier. This site was into the planning board for a compliant, or at least use compliant application. It did pose some practical difficulties from a development standpoint and from an operational standpoint. And the application for a use variance was actually something that was supported really by the Community Development Office, Ms. Savant, and also the county, again, because the site is actually is particularly suited actually for a single-family home versus any kind of commercial use that could possibly go on the property. So from a particular suitability standpoint, we definitely concur with that. And from a standpoint of whether it impairs or is a detriment to the zone plan and master plan of the township or to the public good, I think the applicant has provided testimony that that given the surrounding neighborhood, there actually won't be a detriment to the public good, and given the practical difficulties, I don't think it actually poses a detriment to the zone plan. So that's all I have to offer to the board, but I'm happy to answer any questions the board may have.
And you agreed with the professional's testimony, I would assume?
I do.
Thank you.
I think I just reiterated it, but I do.
Sounded like you agreed.
I think you said it better.
Thanks.
Questions for this witness on my left? Am I right?
Mr. Darcy? So the first commercial idea of placing something there was because of the lot size, it wouldn't work out?
Yeah.
So it's like a catch-22. You can't put a commercial, and you're not allowed single family.
That's why you
Yeah, absolutely. Yeah, that's correct.
So what would go there?
Well, that's why God created use variances.
Thank you.
In fact, would there be inutility to this property?
Correct. I can't think of anything less intense than a single-family dwelling. We can't put an industrial there, so we're not looking for anything. We can't put anything more intense than commercial. We can only go down from there, which is single-family.
Understood. Did you have anything, Counselor?
No, sir. No.
Was that the testimony wrapped up as the engineer and planner all in one?
I think it went back and forth,
went-
yeah.
Okay, seemed good. You going to have any other witnesses, Counselor?
We did provide a brief traffic study. I didn't think it was necessary to have a traffic engineer come in on a single family. The conclusion from the study was that it generates, I believe, 2 trips per day on average, which is, I think, de minimis. So I don't believe the board would need to, we would need to waste time with any traffic
Mr.
testimony.
Georgie, would you agree?
I do agree, yes.
Thank you. So you do have no further witnesses,
That would be
right?
no further
Do
witnesses.
you mind if I go to the public portion at this point?
Not at all.
Okay, what's the number on this? This is 03-2024Z. The physical location is Englishtown Road. It's right at the intersection where Gordon intersects with Englishtown Road, if you're familiar with that area. Anyone here in the room want to be heard on this matter? Please raise your hand or stand. This will be the only time you could speak on this matter tonight. All right, no one has. I'll close the public portion. Final comments, sir?
Quite frankly, after the recitation from your planner, I really have nothing else that I could say. So,
Okay, you realize that we do have 6. You are asking for a D variance.
I did speak that over with my client earlier in the meeting, and we did want to proceed tonight.
Okay. I'd be interested, the owner is the tile, it's Elite Marble and Tile. Were these the property owners further up the road on Englishtown Road?
I would have to ask them if they.
The tile store? No?
No,
Okay.
I believe that's a different tile store.
Okay.
One thing I do want to mention, though, that I failed to mention that was in the report, there was that we would not use this as some sort of a storage location for tile and for, what we had essentially initially applied for, and we would certainly agree to that. This is going to be a single-family home. It is not going to be used for any sort of.
Right, and that's its only purpose.
Correct, exactly.
Okay, it's not going to be for a single-family home with offices like the one you spoke about.
No, now it might be decorated with the nicest tile you've ever seen, but that
Right,
doesn't mean
that's true. Well, I would agree with you. That road, as you traverse it all the way up and down within the township's border, has more homes than it has businesses on that side of the street, certainly. And Park and all of Austin and all of those behind there are all, I guess that's all R6. So there's no business back there. I think there's one church on Park, if I'm not mistaken. Having said that, I'm going to support this, but I don't know how the board's going to vote. I realize this is an EDO zone. We don't normally approve that, but I find this to be unique and obviously a challenge to the owner to do something with that property. So I feel that you've met the burden, and I think you've put the right proofs on the record to satisfy my curiosity anyway, and certainly my support.
Thank you.
Let's see how the vote goes. Okay, someone interested in moving this for approval for, this is D1 use for residential home. This is an EDO zone.
Testaverde.
For approval? Is there a second for approval?
Gomez.
Moved in second, roll call, please.
Ms. Chevalier?
Yes.
Mr. Scogno?
Yes.
Mr. Stoner?
Yes.
Ms. Testaverde?
Yes.
Mr. Singh? I'm sorry, Ms. Gomez? Yes. Chairman Sullivan?
Yes, good luck on that project. Something needs to go there anyway, so.
Thank you. Thank you, everybody. Have a
Best of
wonderful
luck. Thank you for your professional opinions this evening.
Oh, you're welcome.
All right, one final to go. Okay, this is the final matter of the evening. This is 03-2025Z, Prime Space Capital LLC. This is Zone R40, Block 1809, lots 1, 2, 3, and 8. 12 Pine Street, Old Bridge, self-storage facility. This is seeking bifurcated D variance, applicant seeking a bifurcated use variance to develop proposed 3-story self-storage facility. I have Salvatore Alfieri Esquire, but I know you are not him. Oh, yes, you are.
No, I'm not.
That's your dad.
That is my
Okay.
father. Thank you, Chairman. Dante Alfieri, on
Yes,
behalf of the
Dante.
applicant.
Much better looking than your dad.
Younger and better looking version.
Remind him of that, will you?
That's my usual line.
I got to change glasses now. I can see better. Go ahead, Counselor.
So as Chairman stated, we're here seeking the board's approval for a bifurcated use variance application. The client is Prime Spaces Capital LLC. It's block 1809.
Hold on one second. You got no court reporter? There you go. Well, by rule, we require one. If you want to waive that, that's on you. I mean, would I be correct, Mr. Dasty?
Yes.
Hold on one second.
Yeah, no problem. While we're waiting on that, I'll tell the audience, obviously, that I would assume most of the people here are here to hear this application. I'm going to extend the time to as much as I can. We'll probably go right up till 10:30. And I do have to get a public portion in, however.
Understand, yes.
Oh, you're going to, okay. We'll do a restart, okay?
Perfect, thank you.
Yeah, no problem. Those at home, we're just briefly waiting for the stenographer to set up to take the testimony down in this application. You let me know when you're ready, Deanna. Yes? Okay. All right, this is the final matter of the evening, 03-2025Z, Prime Space Capital LLC. This is in the R40 zone, block 18091, lots 1, 2, 3, and 8. Physical location is 12 Pine Street, Old Bridge, for a self-storage facility. Dante Alfieri is representing the applicant. Mr. Alfieri.
Thank you, Chairman, members of the board. Dante Alfieri on behalf of the applicant. As the chairman stated, we are seeking the board's approval for a bifurcated use variance. This is Prime Spaces Capital LLC. A property address is 12 Pine Street, block 18091, lots 1, 2, 3, and 8. I do have 3 individuals to provide testimony. Sitting to my right is our engineer, Mr. Seawald. We do have our traffic expert, and we have a planner available tonight. So given the limited time we do have, and we do appreciate the board's making time for us tonight, I'm just going to jump right into it and have our engineer come up.
Thank you.
Sir, do you swear or affirm to tell the whole truth and nothing but the truth?
I do.
Give us your full name, spell your last.
Josh Seawald, S-E-W-A-L-D.
And Mr. Seawald, could you please provide your qualifications for the board?
Certainly, and I'll keep it brief. I have my bachelor's and master's of science in civil engineering. I was last before your board in January earlier this year for the townhouse project, and I'm a partner at Dynamic Engineering Consultants and spend most of my nights doing land use board meetings.
Mr. Seawald is familiar to the board. We do accept his credentials and expertise.
Thank you, Mr.
Thank you,
Chairman.
sir.
If you wouldn't mind putting up the aerial map exhibit.
Is your mic on?
Yes. Green.
I'll move it closer.
Yep.
All right,
Yeah.
there you go.
The exhibit that's about to come up before you is an aerial map exhibit. This is the same sheet that is part of the bifurcated use variance drawings that were submitted before the board. The property is outlined in red. The blue lines that you see are the zone lines, come right from the Old Bridge Township zoning map. And what we're going to do quickly is go through the existing conditions of the property before we get on to the proposed aspect of the application. The property that's before you on the aerial map exhibit is uniquely shaped parcel. It's 8.53 acres in size. It is a corner property with 660 feet on Route 18, and another 400 feet on Pine Street. Wetlands impact a large majority of the property located on the northern side of the parcel. We have done a delineation, and an application before the DEP is pending. We are anticipating a 50-foot buffer associated with the large pocket of wetlands on the northern side of the parcel. To the north of our large tract of land is the R6 zone and residential houses. To the south of us, our frontage was on Pine Street, and across the street from us is the Old Bridge MUA Water Quality Treatment Plant, some trailer storage, as well as some additional residential homes. To the east, of course, is our large frontage on Route 18 with the R15, R17 zones beyond. And to the west of us is the R40 zone, which is the residential homes. This property is zoned R40. And even though it is zoned R40, the property is currently developed with some commercial use out there. If you look it up online or driven past the property, it is a suburban cap facility. That is a commercial and retail sale of truck tire caps. That technically is an existing non-conforming condition. You can see it on the aerial, and I'll use my laser pointer for you, right at the corner of the property of Pine Street and Route 18. In addition to that, there's a total of 7 structures spread throughout the property today. The remaining structures that are not associated with the suburban cap facility are residential homes. In addition to that, there are multiple other accessory structures, including garages, sheds, and some shipping containers as well. Finally, there's paved drive aisles and parking spaces spread throughout the property. And if you wouldn't mind rolling to the site plan rendering, it was the second exhibit underneath. It's a big file. So while that loads, this is the site plan. There we go. Thank you so much. If you wouldn't mind actually zooming out 1 or 2 clicks. This is the site plan overlaid onto the landscape plan directly from our bifurcated use variance set and then colored for presentation purposes. Same orientation as the aerial map, Exhibit A1. To the north is to the top of the plan, bottom is to the south. Pine Street runs at the bottom, Route 18 is on the right side. On the northern side of the property, you see a lot of different green colors. That's the wetlands and existing woods and trees that are not to be disturbed. The orange box that you see is the focus of tonight's application, which I'll get into shortly. And the light gray colors is the access aisles and parking facility associated with our project. So what are we here for this evening? We're here for a proposed 3-story, Class A modern, climate-controlled self-storage facility. It has a 41,000 square foot footprint, and with its 3-story tall structure at 35 feet tall, it is 123,750 square feet. So approximately 123,000 square feet total. How did we come up with the site plan and what you're looking at this evening on Exhibit A2? Essentially what we're looking to do is demolish all of the things we just discussed on Exhibit A1. The suburban cap facility, all the paved aisles, the 7 different structures, all the ancillary structures will all be removed from the property. What we will then do is we'll start at Pine Street, and we're proposing 1 full movement driveway. That 1 full movement driveway will be on Pine Street only. We have no proposed access to Route 18. We also provide a 2-way, full circulation, 30-foot drive aisle around our facility, both for fire access as well as for our users and clients of the facility. We're proposing 13 parking spaces. Those spaces are between the building and Route 18. Those spaces are compliant with the size at 10 by 20. We do require a variance for the total number of spaces. Your ordinance contemplates approximately 25 parking spaces. You're going to hear testimony from our traffic engineer as well as our planner throughout this application that self-storage uses don't need a lot of parking. They don't generate a lot of traffic, even though it's a slightly larger building than what's anticipated compared to other commercial uses. So because of that, it's good planning to have less impervious coverage, less disturbance, and keep as much existing trees and vegetation as you can. So overall, we will have 13 parking spaces to facilitate this property. One of the comments in your board engineer's review letter talks about the number of EV spaces. We will certainly comply and round that up to a proposed 3 EV parking spaces. Another variance that we have associated with this layout is no formal loading zones. The Old Bridge ordinance talks about loading zones based on square footage. If this board is familiar with any climate-controlled self-storage facility, you don't have a formal truck dock where you have a sunken loading dock that you would maybe see at a grocery store or a striped loading space maybe next to a Wawa. What our customers do is they drive into the property, they park outside in the paved drive aisle, and then they go into the building through 2 entry points. So there's no formal loading due to the low intensity associated with this type of use. How did we come up with this layout? We designed the development in order to comply with the bulk setback standards of the R40 zone. And I know that sounds funny because usually we're here and we're talking about a commercial or industrial zone, try to comply with those bulk standards. One of the benefits of this property being over 8 acres in size, with a lot of frontage on public right-of-ways and a lot of wetlands area, you get to centralize this building and provide as much green space around all 4 sides of the building. So I'm happy to report that the building is 95 feet from Pine Street, 150 feet from Route 18, 114 feet to our residential neighbor to the west, that's our neighbors on Pine Street, and then another 365 feet to our residential neighbors to the north. We thought that was very important because when looking at this site, obviously the significant portion is we're putting this commercial facility next to some of our residential neighbors. So we wanted to ensure when we went through our site plan design that's showing on Exhibit A2 that we thought about that, and we kept the building as close as possible to the corner of Pine Street and Route 18 and maximize that green space along our residential neighbors. We do need a C variance actually for placing the parking in the Route 18 buffer. You'll hear from our planner later this evening that from a site plan design standpoint, we thought it was better to keep that development closer to Route 18 and maximize that buffer to the western residential neighboring lines. However, should the board really request that Route 18 buffer, we do have the real estate to shift the development to the west. But we thought that the plan that we're presenting before you is a better layout. Another important aspect of the layout is looking at the R40 zone from a landscape ratio. That's what Old Bridge does to monitor impervious coverage and basically development intensity on the property. In the R40, you are looking at a 65% landscape ratio requirement. The application, and shown on Exhibit A2 before you, is providing 80%. So we're only developing approximately 20% of the overall parcel. However, we are here, in fact, before you at the zoning board because of that D1. Self-storage was not contemplated in this zone or the underlying residential. Again, you will hear substantial proof and testimony from our planner. However, I just wanted to point out some particularly suitable items from a site plan standpoint. As I mentioned, going through the A1 and the A2, the site is unique characteristics. Even though it's zoned residential, it has an existing commercial facility that's been there for quite some time. It's unique that it's a very large tract of land at 8 acres with hundreds of linear feet on 2 public right-of-ways. In addition to that, the redevelopment of this property will actually remove one of those existing nonconformity retail facilities and demo a lot of the structures that are already inside of the bulk standards. What we're able to do with the site plan is condense the development, bring it inside to the site, and then provide a lot more landscaping that is not out there this evening. So overall, what we're looking for, again, is the site plan that is, we thought we've put a lot of good design practices to make sure that we're being sensitive to our neighbors and shifting the development away from both Pine Street and the residential neighbors so that should you be driving down Pine Street, you're gonna have at least 75 feet width of buffering and landscaping before you can see the first drive aisle associated with our self-storage facility. And that is the end of my direct testimony of Exhibit A1 as well as Exhibit A2.
Thank you. We open it to the board for any questions.
Mr. Dargy.
Thank you, Mr. Chairman. Being a D1 use variance, the bulk of our review memo really deals with the planning aspects of the application. From an engineering standpoint, really that takes a second. It sort of is a secondary thing because should the board act favorably on the use variance, then we can get into the actual hard engineering. The engineering aspects that the board usually does consider at this stage, at the use variance stage, really are things like environmental impact, traffic impact, and things of that nature. And I think the applicant has the traffic engineer that's going to be testifying about traffic, so we'll wait on those. Question I do have regarding the actual facility itself. Can you just speak to restrictions or things that you're going to because I imagine you're familiar with this particular use. Any restrictions that the operator is going to have with regard to what can be stored there, how lease restrictions and things like that?
Certainly, and that's a great question, Mr. Dargy. We did submit some preliminary architecturals. One of the unique components of this 3-story facility is that there's no roll-up doors. Very common in those single-story self-storage facilities or even these multi-story ones, you will have perimeter and exterior roll-up doors where you could either, say, drive in your car or have a larger unit. There is no exterior doors. And one of the reasons why the applicant, Prime Space, decided to do that in their building design so that you don't hear any of the noise of the roll-up door going up or coming down. All of the activity is inside the building. So you would pull up to the facility, go through the doors, they would close behind you, and then you would walk in the interior hallways to get to your unit. They also have elevators inside to take you to floors, of course, 2 and 3. So that, I would say, is unique. If you look at a lot of the other 3-story facilities throughout Old Bridge and Middlesex County, you will see those exterior perimeter doors. In addition to that, some of the other more modern self-storage has what we call big loading areas. There's a tall, sometimes 1 or 2-story canopy where you drive something in and the door closes behind you. Same reason as the unit doors. The applicant did not want to propose that here because of our residential neighbors. In addition to that, they will certainly provide through the leasing that you cannot house any hazardous materials, which is very common within the self-storage facility. And that's a high-level summary of some of their. If there's anything else, Rakesh, I'd be happy to answer.
One of the other things that that we do discuss at the for self-storage facilities is people who have online businesses and things like that using this facility for their storage or a drop ship kind of situation. Does the applicant have any restrictions with regard to that? Because a lot of times one of the benefits, if you want to call it that, benefits that applicants tout about self-storage facilities is no traffic. It's a 130,000 square foot building or 120,000 square foot building that produces 6 peak hour trips, which is great. But that sort of, I won't say falls apart, but that sort of gets degraded a little bit when you start considering people that may have units that are using them for an online business or things like that. So does Prime Space have restrictions in their lease agreements about that?
So they certainly don't allow what we call that e-commerce type, where somebody would be coming in every single day, basically operating it as a small
little warehouse.
Correct, exactly. However, they certainly don't restrict one of their customers, maybe being the local electrician that has to store parts, or maybe they have a seasonal aspect. And that goes right along with Mr. Dargy's question about the traffic and intensity of a self-storage use. And one of the other aspects of this site is we're limiting it to 13 parking spaces and no extra loading areas. Sometimes you'll see big parking areas, maybe oversized spaces for RVs, boats, or their trailers, their landscape trailers. None of that is proposed and will be restricted on this site. This has a bunch of small units inside. We expect it for the storage of someone's personal product. They may have a small business component, but there will be no e-commerce warehouse-style development in here.
How about exterior lighting?
So we have not done a lighting plan yet. However, I would expect the majority of the perimeter access aisle to be wall packs. We would probably guess, Rakesh, about 2 to 3 area light poles, one near the driveway for safety and maneuverability, and then maybe 1 double head fixture near the parking lot. So very low amount of light generation and only wall packs that illuminate the drive aisle around the building.
Okay. And the rest of the comments, Mr. Chairman, in our memo, we have other comments regarding traffic and planning, but as far as the engineering goes, we do have some comments in there that really are more of a advisory. So should the board act favorably on the application, we have some comments for the applicant to bear in mind when they prepare a site plan. Do you have any objection to any of those comments, Josh? I mean,
The only one, not an objection, we wanted to let you know the design intent. So on page 7 of your report, Rakesh, items 13 and 14 talk about the architectural facade treatments. And the facade facing Pine Street and Route 18 is very nice in our opinion, multiple breaks in it, and there's glass and windows. The western facade has some vertical components, and then our northern facade is kind of blank, and Rakesh outlines that well. And truly, the only reason we were leaving it blank was not that it was at the fourth side of the building. It's because it's 350 feet away from a property line. with dense existing vegetation that's over 50 feet tall that you cannot touch because it's in a wetlands. So that was the only reason. We would ask that to be considered. If it was truly a concern of the board, we can certainly discuss that with the applicant.
Understood.
But everything else, Mr. Dargy, is fair, and we'll condition that as part of a potential site plan application.
I don't have any other questions for this witness, Mr. Chairman.
Alfieri, this is a preliminary and final site plan application as well as a D and a C variance.
This is only bifurcated for the use portion.
I'm sorry?
This is only bifurcated for the use. We're going to come back for site plan
Oh,
approval.
it says here, you've received plans for preliminary and final major site plan, but it's.
That's a typographical error in my memo. I apologize.
We're only
But
here
yes,
for the use tonight.
we did review it as a bifurcated use variance.
Are the bulk variances being requested tonight?
They're assumed, but we'll touch on those as well if you.
And Mr. Solicitor, I tried to address the engineering items that Rakesh's report went through, the parking and the loading. So we, as Mr. Alfieri mentioned, we would like to consider that subsumed, but Christine will discuss that shortly.
Mr. Dargy, you're good, right?
I am, Mr. Chairman.
On my left, questions of this witness.
Yes, is there anything on the property now?
Yes, sir. There is Suburban Caps retail facility. They sell like caps for tractor
Yes,
trailers.
yes.
That's at the corner of Pine and 18.
Mhm.
And there's 7 other structures throughout the property, most of them residential. And then there's ancillary garages, sheds, shipping containers, and other items.
And what's going to happen to that cap company?
They are selling the property to our applicant.
Oh, they're selling it to you?
Yes,
You
sir.
demolish that and then build your
That is
structure?
correct. Yes.
Thank you.
I have a question.
Yes, sir.
Where's the fire hydrants?
Say that again, sir?
Fire hydrants?
The existing or proposed?
Proposed.
So proposed, we don't have the detail on that. That'll come through preliminary and final site plan drawings. However, I'm confident to let you know there is a water main within Pine Street, and we absolutely will have a fire hydrant on site. Your fire official did send us a review letter last week. We spoke with him personally, and all of his comments that he asked in his review letter will be addressed. In addition to that, the building will be fully sprinklered as well.
That was my next question. Okay, thank you.
Anytime.
Anyone else?
Are the residents occupied?
You're talking about the homes that are on there. That was going to be my question, yes.
I would have to ask my applicant. I don't know, ma'am.
Well, that's kind of important.
Planner, maybe the planner will know that. Okay. Was going to be my question. What are you going to do? Are people moving out of the homes on there, or they're not living in them presently?
At the time of my investigation a year ago, not all of the homes were being lived in. A lot of them were vacated. But just to build the record correctly, I will ask, once I step down, to make sure every home has been vacated.
Mr. Testaverde, nothing? Counselor?
Mr. Alfieri, I'm a little concerned that although it's a bifurcated application, there's no traffic report yet.
We have traffic testimony tonight, and I believe we did submit it.
There is a traffic report.
Yes, we submitted a report.
Okay, excuse me. Sorry about that. Go ahead. Thank you.
All right. Let's go to the next witness.
Certainly. So now we're going to call up our traffic expert, Mr. Chase.
Sir, would you raise your right hand? Do you swear or affirm to tell the whole truth, so help you God?
I do.
Your name and spell your last, sir.
Certainly, it's Corey, Corey. Last name's Chase, Chase. A licensed professional engineer in the state of New Jersey, principal with the firm Dynamic Traffic. My engineering license is currently in good standing, and similar to Mr. Seawald, I appeared before the township in January.
We'll accept your credentials. I just wanted to make one comment to those sitting here. You're not being forgotten. I just haven't opened a public portion yet. All of these people are going to be subjected to, if you have questions about it, you can address the board and we'll get the information for you. So you're not forgotten. Please don't leave. Sorry.
Thank you. Take it away, Mr. Chase.
Thank you. As Mr. Seawald mentioned, we did prepare a traffic impact study, and if you could please pull up applicant's A2, the site plan rendering, that's what my testimony will refer to. We did prepare a traffic impact study as part of the application. It was dated December 19, 2024. Mr. Dargy did acknowledge receipt and review of that traffic impact study as part of his review letter. In preparing the traffic impact study, we did manual turning movement counts at the Pine Street intersection with Route 18 southbound to do a pre- and post-development analysis of that intersection to see if there'd be any detrimental impacts as a result of the redevelopment of the subject property. As the board's heard me testify to before, we consult data published by the Institute of Transportation Engineers, which is the national and state recognized standard for developing traffic projections for a variety of uses, including self-storage facilities. Those traffic generation projections are summarized on Table 3, which is on page 5 of our report, and it's based on the overall square footage of the proposed self-storage facility. As Mr. Dargy correctly noted, self-storage facilities, as far as commercial developments go, are one of, if not the lowest traffic generator there is for a commercial type facility. You can see we've, again, focused on the weekday morning, the weekday evening, and the Saturday midday peak hours, so those peak critical periods, assessing what the development traffic would generate compounded onto the existing traffic volumes on the adjacent roadway, and then determine if there are any degradations in operational conditions. As you can see, the maximum traffic generation during any one of those peak hours is 21 total trips. So it's approximately 1 trip every 3 minutes during the peak period. To give the board an idea as to what that level of traffic generation constitutes, the New Jersey Department of Transportation has set a threshold of 100 additional trips during a peak hour is what they term to be a significant increase in traffic. So this use would generate approximately 20% of that significant increase in traffic. So from a pure traffic generation standpoint, approximately 1 trip every 3 minutes, again, a very low traffic generator. We did not take any credit for the existing use on the facility, so we assume that all this traffic was new over vacant land to provide a conservative analysis of our overall traffic impacts on the adjacent roadway network. We did do a pre- and post-development analysis at the NJ Route 18 intersection with Pine Street, and that's summarized on Table 4, which is located on page 6 of our report. It provides the pre-development condition without the development, and again, not taking any credit for the existing uses on site, just supplementing on all the additional traffic generated by the proposed self-storage facility, and then reanalyzing that intersection. As the board can see, there are no degradations, so no changes in the operational condition at the Route 18 and Pine Street intersection during any one of those 3 critical peak hours. In addition, we also analyzed the site access point along Pine Street and found that that would operate at acceptable levels of service. As Mr. Seawald mentioned, we are reducing the access points to the subject property along Pine Street. There are currently 2 driveways today. We'll be consolidating that into 1 singular driveway in the proposed condition. We are also proposing to provide 13 dedicated parking stalls on site. The Institute of Transportation Engineers, in addition to the trip generation manual, they also publish a parking generation manual, which provides parking statistics for a variety of uses. And based on that information published by the Institute of Transportation Engineers, 13 spaces is sufficient for a use of this size. Mr. Seawald and myself have worked on dozens of these applications, and they typically provide somewhere between 10 and 15 parking spaces. So providing 13 is right in that sweet spot, typical for a facility of this size. Mr. Seawald also noted we are not providing any formalized loading spaces, whereas 5 spaces are required per ordinance. As Mr. Seawald did also note that there are oversized drive aisles on all 3 sides of the site. Typically, you provide a 24-foot wide 2-way access aisle to circulate a site. These access aisles are all 30 feet in width. So there are doors on both the northern and southern building facades. So it's anticipated that although there are no roll-up doors on the exterior of the building, that vehicles will pull along both the northern and southern building facades, park their vehicles, utilize those entrance doors, which are located at approximately the midpoint of the building, to access the internal corridor and the elevators should they choose to go to the 2nd or 3rd floor. So overall, from a traffic generation, traffic impact standpoint, certainly not a significant increase in traffic, no degradations in the operational conditions on the adjacent roadway network. Mr. Dargy, as he mentioned, did have some recommendations as far as additional signage and striping that could be provided on site to further emphasize where vehicles could and could not park, and we're certainly amenable, should the board act favorably, to incorporate those into any site plan application. Mr. Alfieri, that's all I had for direct testimony. I'd be happy to answer any questions that the board or Mr. Dargy has.
Thank you, Mr. Chase.
Mr. Dargy?
Thank you, Mr. Chairman. Mr. Chase, did you analyze the site for maneuverability for delivery vehicles, fire trucks?
We did work with Mr. Seawald's office. I know that you mentioned that I don't believe a truck turning exhibit was submitted as part of the use variance application. We did analyze that, and we'd certainly include that as part of any site plan application. But we did analyze that and found that there is sufficient maneuvering area.
So the site, the plan as depicted in the variance application accommodates those vehicles?
That's correct.
Okay, because that's important, because we want to make sure that what you're seeing is what you're going to get if you do act favorably on the application, that the site plan doesn't drastically change from what the applicant's presenting to the board this evening. With regard to traffic, I do concur as far as the traffic goes. These facilities generally, once they're occupied, do generate very little traffic. 21 trips in the peak hour is not a significant number. It's really the impact of the aesthetics of a building like this more so than the traffic from a building like this. I'm trying to think. And then, as far as DOT goes, have you had any conversations with DOT?
We have not, and I apologize for not touching on that in my direct, Mr. Dargy. We are not proposing any improvements within the DOT right away, although we do have frontage on Route 18. All of our improvements are proposed. DOT's jurisdiction actually ends where the curb stops on Pine Street. It's a pretty defined line. You can tell where that ends. So all our improvements are located outside the DOT right away. So we would not be required to get any, not even a letter of no interest in this case, because no work is being performed in the DOT right away.
Okay. Mr. Chairman, I don't have any additional questions for this witness at this time.
Okay, thank you.
I'm sorry, I have one question. On the 13 spots, are there handicap spots located in those 13?
Yes.
There is an ADA parking stall. It's located the southernmost parking stall on the eastern building facade.
Yeah, and I'll touch on the parking real quick as well. Typically, I'll concur with Mr. Seawald and Mr. Chase's testimony with regard to the number of parking spaces. Our ordinance, I think, when we calculated, it doesn't specifically say self-storage facilities. There's a it's actually labeled in our memo. It's similar kind of use, but it comes out to about 25 spaces, which is an excessive amount usually for a self-storage facility. So I would concur. Not a use like this, a building of this size typically only needs 13 to 15 parking spaces. Anything more really would be unnecessary or superfluous pavement that would, we tend to shy away from.
Questions on my left of this witness? Mr. Scogno.
This is only a 2-lane, is that correct? Coming off of Route 18, that's 1 lane in, and then exiting Pine Street is 1 lane out.
That's correct.
Nothing on 18, only on Pine.
No, I mean, you have to enter Pine from 18, one lane.
Yeah, Pine Street's
And-
only.
And to exit Pine, you're on the right side, exiting out to 18, and you're going southbound.
Correct.
And 12 Pine Street is a home. The address, the 12 Pine Street, there's a home there. That's the address of a home.
As Mr. Seawald mentioned, there's
Yeah, I know, he mentioned a cap company.
and there are several.
There is a
dwelling-
cap company there, but there are homes there,
Correct.
And he mentioned that in his testimony.
and not to me. Thank you.
Anybody else on my left? No. Am I right, Counselor?
No, sir.
I have nothing.
Thank you.
Thank you.
And our last and final witness is Ms. Cofone to provide some planning testimony. And before she comes on, I just wanted to, with regards to the residential uses, there are 3 units that are being rented on a month-to-month basis at this current time.
Okay.
Ms. Cavone, do you swear or affirm to tell the whole truth and nothing but the truth?
Yes.
Give us your full name, spell your last.
Yes. My name is Christine Nazaro, Nazzaro, Cofone, Cofone. Business address is 52 Reckless Place, Red Bank, New Jersey, 07701. Testifying this evening as a licensed professional planner. I've been a planner for about 29 years in the state of New Jersey here. I have been qualified in Old Bridge Township on numerous occasions, as well as in excess of over
Thank you
400
for putting your
planning and zoning
credentials
boards.
on the record. We're very familiar with you. You've testified here numerous occasions
Thank
over
you,
the
Chairman
years.
Sullivan.
Take it away, Ms. Cofone.
So the application, I know we've heard a lot of testimony tonight, but the reason we're here seeking the use variance, despite that the fact that the site is currently developed commercially as well as residentially, the R40 zone where the subject property is located does not allow for the self-storage facility. In addition to that, the board has jurisdiction because we need a D4 variance for the FAR, the floor area ratio. The FAR in the R40 zone is allowed at 0.13. Existing is 0.026, and we are proposing an FAR of 0.333. So those are the two D variances that we need in conjunction with this application. There are also a number of bulk variances. Mr. Seawald went through them. I'll touch on them as well, but we need a bulk variance for the maximum number of stories. 2.5 is required in the zone. We're proposing 3. The parking spaces, which was also testified to, based on your ordinance, we would be required to have 25, where we're providing 13, although we do get credit for 19 due to the fact that we are providing 2 EV spaces. Having 0 loading spaces versus 5, which would be required for a building of this size. Having our parking drive within 75 feet of Route 18, although Mr. Seawald did testify that we could shift it over more to the west, which puts us closer to the residences. We felt that it was a better zoning alternative to have that parking and that activity associated with it more proximate to Route 18. Similarly with the buffer along Route 18. And then I do think we need some relief for the number of EV spaces that we're asking. So that's essentially the relief that we're asking for. To the extent the board will defer sign variances to the site plan, we would need variances for the signs associated with this application as well. The signs as proposed and shown to you on the architectural drawings that were provided show signage on the southern and eastern portions of the building only, so none on the north, none on the west facing the residences. So they'd be facing Route 18 and they'd be facing Pine Street. As far as particular suitability for the D1, we have an obligation to demonstrate the site is particularly suitable, right? We don't have to demonstrate that it's only this use can go here or that we have to rule out other locations. Just there's something about this site that makes it particularly suitable for this use. Mr. Sewell did a great job, as he always does, of laying the foundation for that and telling you about the site. This is an 8.53 acre site. And the northern portion of it, as you saw from that substantial green, if we want to bring back up the site plan would be amazing. It's undevelopable. So this is a great site to have a building that has very little reliance on having a large surface parking lot because we are somewhat restricted here in where we can develop the property. Additionally, the hundreds of feet that we have on Route 18, in my opinion, could be looked at as something that renders this site particularly suitable for the proposed commercial use. So those factors, the 660 feet on Route 18, the 8.53 acres of the site, the fact that it's developed with an existing commercial use, the fact that it's encumbered and this use requires very little in the way of surface parking lot, and we are eliminating a number of bulk variances on the site. Those things are that I think the board can take notice of for particular suitability. With regard to the special reasons or the positive criteria that exist, and they come from the land use law, they're not unique to Old Bridge Township, they come right out of the municipal land use law at 40:55D-2. Statutorily, we only have to advance one to satisfy our burden of proof, but I believe there are 2, at least, that are advanced. Certainly criteria G talks about sufficient space in appropriate locations for a variety of uses, and criteria M talks about an efficient use of the land. When you're dealing with a site like this that is constrained and has some other challenges with respect to developing it, I think that the applicant has come up with a program that takes into consideration the unique features of this site as well as the residents that surround it. So I think certainly criteria G and criteria M are both applicable to this application. With that being said, you have to also use both burdens of proof with respect to the negative criteria. The board would have to look at that. And the land use law does not ask you to hold us or any other applicant that there be no detriment, just that the benefits of the grant of the variance would be outweighed by the benefits would outweigh any detriments. And here, and there's really 2 prongs to the negative criteria, the impact on the zone plan and the impact on the public good or the surrounding properties. And I think this is a site that, as Mr. Sewell testified to you, will maintain 80% of landscaping ratio. That's very substantial and far in excess of what your zone contemplates for this area. We also are providing that we would have no roll-up doors, that we would have no outdoor storage, no oversized vehicles, and that we have our parking and that activity oriented to the Route 18 side. All of those things, in my opinion, inform my decision that we will not have a substantial detriment on the zone plan or the public good. As far as the zone plan, when you look at the R40 zone, yes, it is a predominantly single-family zone, but it is certainly not without permissible commercial uses. You could have a daycare in that zone. There are a number of other uses that are allowable conditionally. Schools are permitted. Daycares are as of right. You could have a museum that's conditionally permitted. A convalescent or rest home would be conditionally permitted. So while it is predominantly a residential zone, there are certainly a number of other uses, institutional and of a commercial nature, that would be allowable as of right. And with the use before you, as you've heard from our team, as well as, Mr. Akish, that this is a very sleepy use. My office has done dozens of self-storage facilities, and we've done several here in Old Bridge Township. Most recently, the Extra Space self-storage, I testified on that. So this is, again, we've done literally dozens of them throughout the state, and this is a notoriously sleepy use. I think that at 13 spaces, it's probably overparked for some of the ones that we've done. 13 is probably on the higher scale of parking that we see associated with this use. So I see no substantial detriment to the zone plan or the public good if, in fact, the board were to move favorably on this application. As far as the D variance for FAR, unlike particular suitability and other things that you hear when you're dealing with a D variance for FAR, the test really there is can the site handle the excess FAR? And very difficult to come to the conclusion when you have a site that's got an 80% landscape ratio and certainly the ability to buffer and to park it, that you can't handle the excess FAR on the site. The last point I would like to make is that there are substantial recommendations in the master plan to increase and improve non-residential development in appropriate locations. This is an existing commercial site, despite the fact that it is in an R40 zone, but I think the application that you have before you this evening is a substantial improvement over what is existing on the property today. So I believe that we meet our statutory burden of proof with respect to the D variance. And as far as the Medici reconciliation, the omission of this is what I would consider a site that is on the fringe of the R40 zone. We are immediately adjacent to a major state arterial, Route 18, and then this really becomes like a transitional use into the neighborhood along Pine. So in my opinion, we meet our statutory burden of proof with respect to the particular suitability, the positive and negative criteria, as well as the Medici reconciliation. As far as the bulk variances, I believe the board can look at them under both the C1 and C2 section of the statute to the extent that they are not subsumed into the D1, which I believe they would be. I believe that the bulks are still arguable in that they just represent a better zoning alternative. Could we eliminate that variance where we had our parking drive and more of a buffer along Route 18? We could, but then that's taking space away from the western border, and we think that this is just just a better layout to bring that activity away to the extent possible. So in conclusion, like I said, I think we meet our statutory burden of proof for the D and C variances associated with this application, and that all can be granted without substantial detriment to the zone plan or the public good.
Thank you, Ms. Cofone.
You're welcome.
We open it to the board for any questions.
Mr. Dorsey.
Thank you, Mr. Chairman. Ms. Capone's provided pretty much all the testimony that goes with the D1 and the D4 variance proofs. With regard to particular suitability, the site is it's a R40 zone, but it fronts onto Route 18, which in this stretch of Route 18 is actually a divided, almost a freeway kind of feel. It's a divided highway. So from a particular suitability standpoint, it actually it does have a merit as a suitable site for a self-storage and providing some sort of transition to residential. The floor area ratio, we're a little unique as far as our zoning goes. Most most times when you have a floor area ratio, that deals in commercial zones, but we actually have a floor area ratio for our residential zone, which is kind of unique. But based off a 40,000 square foot lot, the 0.13 floor area ratio results in a 5,000 square foot house. So it's a reasonably sized house. But for commercial use like this, especially when you're talking about a self-storage facility, that's where you really have to weigh the aesthetics of the building, the mass of the building, that increased floor area ratio lends itself to. So that's the discussion that the board is probably going to have as far as the actual size of the building and whether that is suitable for this location. As far as the actual use itself, there is a site suitability argument to be made. I'm happy to answer any questions the board may have, but as far as any questions for Ms. Cofone, I don't have any questions for Ms. Cofone.
Let me see if the board has any. Mr. Scott, I can see.
I just think it's a huge building.
I agree with you.
Certainly reduced and, I mean, let's face it, that's huge. It could be reduced and then our impervious surfaces are even smaller yet.
I agree.
Do you have any idea how long in existence were these commercial establishments?
The existing commercial, I don't know how long the existing commercial has been
Were
there.
they prior to this, this establishment?
The R40?
of zones?
I would only be taking a guess right now, so I apologize. I can't
Does
answer
that make
that.
our
Yeah.
job a little?
Oh, absolutely. I
more
agree with you.
difficult?
Yeah.
It should be something from the council to change these things.
Suburban Caps has probably been there as long as I know, 40-plus years.
Yeah.
Well, it's probably before these, that they made it a R40, no?
Oh, yeah.
I literally didn't know that there was all those other houses on the property, though.
This makes
Yeah,
our
it's
job-
existed there a long time, and I probably would think, although I don't know, if the owner's here, he probably knows, that it may have spurred from him living there, or he was it was just a side business that he brought onto his property. I don't know that to be a fact, nor am I assessing that it is, but the cap business, I know, has been there for 40-plus years. Anybody else on the board,
No, sir.
Counselor?
No, sir.
You have no more witnesses, Mr.
No.
Mr. Alfieri. Let's hear what I'm assuming the neighbors are here, and I'm sure they want to be heard. So, yes, go ahead.
Question.
Go ahead.
Is there any hours of operation? Do they close or it's 24 hours?
I'm going to defer that.
I guess you would probably bring all that up should you receive the use variance, right? I mean, normally these follow certain hours,
We
but
can provide that, though.
if you want to put it on the record, just come up to the
Mr.
microphone.
Seawald for record.
Yeah.
It is closed overnight. I do not have exact hours. It's approximately 7.
Closed overnight.
It is closed overnight and no access.
Thank you.
No problem.
Oh, I'm sorry. If they have a passcode to get in, they can still get in, right?
Well, it's electronic, so they would not be able to get in. So because there's no exterior drive-up units, it's very easy to control. The 3 doors would then not allow you to get in other than fire access. So even though it's your passcode, it would block you from going in after the hours that the operator allots.
So you could get into the lot, but you can't get into the building.
That's correct.
All right.
Thank you, Mr. Seawald.
I'm going to open up the public portion on this now. This is item 03, 2025Z. This is for Prime Space Capital. We're looking for bifurcated use, and if people have questions about what bifurcated use means, it means they're asking for if we would give permission for the use first, and then they would come forward with site plans, et cetera, moving forward. But if we don't give the use, there's no need for them to come back because it would be denied. So let's just, I don't want to jump ahead, but let's take this in an orderly fashion. I'll try and hear as many of you as I can tonight, but please don't be repetitive. If someone brought up the topic, it's already been brought up, bring up another one, okay? So whoever wants to go first, raise your hand or just come forward. Come on up, sir. You're sitting closest to the microphone.
Just raise your right hand, please, sir. Do you swear to or affirm to tell the whole truth and nothing but the truth?
I do.
Give us your full name, spell your last.
My name is James McNally, M-C, capital N-A-L-L-Y.
Thank you.
Sir?
Okay, I've lived on Darwin Road for 50 years. And not that it has any bearing on you people, but when I bought that house 50 years ago, I was assured that that property was state land and it would never be developed. So how it got sold to somebody in the first place, I don't really know, but neither here nor there. My concern is we have a very high water table there. And when it rains exceedingly, I always get water in my basement. So what is this structure gonna do to that piece of property? Obviously, they're gonna have to take out a bunch of trees, which can't help the water situation. So my question is, how is this facility gonna impact the water table?
Mr. Sewell?
Absolutely. It's a great question and a true concern. So tonight, we're only potentially voting on the use aspect. However, this type of a project, when we come back for what we call preliminary and final major site plan, we have to provide the board what's called a stormwater management report. I'm sure, as you know, being a local in the area, the property today has no stormwater management facilities. The existing commercial structure, the other dwellings that are on site and all the paved parking lot, when it rains, it hits that ground and it runs off into the wetlands to the northern portion of the site. What we would be required to do, based off of Old Bridge and the state standards, we would have to put a stormwater basin to accommodate our runoff. Not just the new runoff from the building, but actually improve the existing runoff so that it not just addresses stormwater for our site, but improves the local sub-drainage area. So one of the benefits of redevelopment work is that the state mandates we improve the site from a stormwater standpoint. It's a great concern, and one of the positives of redevelopment is it gets addressed and helps the sub-watershed in the area from a stormwater standpoint.
Okay. And one other point, if I may make it.
Go ahead.
You were talking about the traffic impact, and I heard what you said, that it's minimal, but is the board aware of the fact that if you're coming northern on Route 18 and you live in our development, you have to make a U-turn at Southwood and then go down Pine Street. So all the traffic that from our area utilizes Pine Street on a daily basis. So I don't know if, your traffic is gonna make that worse, but it's just something to think about.
Thank you, sir.
Thank you.
Who's next? Come on up, sir.
Am I allowed to voice my opinion?
Well, hold on.
I'm going to turn it around for them.
Just move the microphone down a little. No, just, it flexes.
Raise your right hand. Do you swear or affirm to tell the whole truth and nothing but the truth?
Of course.
Give us your full name, spell your last.
Frank Aragona, Aragona.
Thank you.
Mr. Aragon, go ahead.
Okay, this is what you need to do. You need to turn that 90 degrees. You need to get an improvement to get access from Route 18 into your property behind suburban caps. If you want to rent to them, not put them out of business. They've been in business for, 30 some odd years. There's plenty of room that you can make an access, just like Wawa has, just like Dunkin' Donuts has. And that's a better road to come in on than my street. That's very narrow. And as far as the fire hydrant, it's on the corner of my property on Pine Street towards, that would be the west eastern. It's right there, right on the corner. My property line's probably a little bit further. Anyway, you turn the building, you put trees on the streets behind the building because of those houses there. I agree you're far enough away from those houses, but either you put a fence or you put trees on Pine Street. Turn the whole project around. It's like foolish to try to make people come in on my street. The street's narrow. We don't even have sidewalks. Or curbs, which I don't want, of course, but I'm telling you, the better way to do it is turn it, get access from the town to enter on on the, because Route 18 has like a, what would you call it, a service road? In other words, it's not just the 2 lanes and the divider and 2 more lanes. There's a service road, which I would love to suggest that the way the line
To
is
talk into the
painted,
microphone, so
the way the line is painted is so wrong. Because I obey the laws and I go to the end of the line before I turn into my street. It's like 20 feet, not even 20 feet from the street. It should be all the way back so you could get into the apron and to have time that the clown behind me is not looking to push me off the road. So that's my suggestion. You turn the building, you buffer it with trees so you're not, or a fence, I don't care. Me, I don't care, because I'm a live and let live. But to put suburban caps, maybe you could rent to them that area, because you're gonna buy the land, obviously.
Let me
And put that building, put them people out of business that have been there for 30-some odd years.
So let's talk about that, and then I'll answer all your other comments and questions.
Okay.
Happy to answer as much as I can.
Go ahead.
Suburban Caps and the property owner, we're not forcing them to do this. They made an agreement with Prime Space to sell the land, and then Prime Space decided that they would like to do the self-storage facility. So they are together on this, we're not forcing them.
Yeah, I have no problem with the self-storage, no problem.
I'm just letting you know, we're
But
not
putting
forcing
people
the current
out
owner
of-
to do that.
I'm a little bit not happy of putting people out of where they're living, because you got rental people there. You don't have owners. The one house is abandoned. That used to be Mr. Zappi's house when he was a kid. They own that house. There's nobody in it. There's a barracks right in front of I don't care. 2 out of 3 of those apartments that this barracks has got people in it that have children, young children. Then you go down alongside the suburban caps, it's not a road. They made it a road. Mr. Zappi made it a road years ago, and there's 4 bungalows back there.
Agreed, sir.
I'm pretty sure 3 of those bungalows have people in them. The one in further is like a disaster. And of course, the White House, the old house that Mr. Zappi, there was somebody in there, but he since moved, and it never was re-rented. And there is sheds in the back, and it needs to be cleaned up. I have nothing against that. But if you ask me, you need to turn it and come in on 18.
We certainly looked at that. We want the board to know that we looked at that. There are wetlands along the frontage, and as it gets close enough to the corner where I could possibly sneak in a driveway, it's too close to the intersection then with Pine Street.
How many feet you got there from my street?
So see how there's that big piece of grass and that property's kind of angled?
That belongs to the town.
That belongs to the DOT.
There's a fence along suburban caps that's on an angle.
Yes, sir.
So that piece of land,
That's the DOT, that's the state land.
oh,
So we certainly looked at that. It makes sense, right, to take a commercial facility tied in because of the wetlands buffer, and a lot of that land that is not allowed to have a driveway, we were looking to propose it to Pine Street. You're also very close from a traffic safety standpoint at your Pine Street intersection with Route 18. So we certainly looked at it. We hope that the traffic report that Mr. Chase put together, that even though it is a larger building, that it does not generate a lot of traffic.
so you're saying where you turn at Salter Drive, the red light, that's wetlands right over there?
Yes.
That part of it?
Yes.
I think you could come further, you could come towards the street, or is it wetlands all the way to Pine Street?
All of this area and down to about right here is all wetlands with associated buffers. In addition to that, all these little circles that you see, just to address your comment that you had before, is all proposed vegetation to act as a buffer.
Yeah.
And then all of this back here is an existing vegetated area that we will not be disturbing. So to answer one of your comments earlier, and I'll talk into the mic, about buffering it, our goal is so that when you are driving on Pine Street, you will have wider than 50 foot of multiple rows of trees and buffering.
Yeah, I understand. You said it's 95 feet back or something like that.
The building is, yes, sir.
Yeah, okay. So, in other words, turning it, you can't come in from 18 because it's wetlands?
again, we could potentially turn it. Our thought was the shortest side of the building should be near the western residential, and we wanted the longer side of the building facing an area that you couldn't see. We certainly could rotate it 90 degrees, but then you have a bigger mass along a western residential property line.
Right.
So that was our thought. It's not a wrong design alternative, but we thought this was better because the bigger mass of the building is now facing an area that you can't see.
But you're saying it's going to be buffered with trees and stuff like that?
All of that is existing woods that are over.
Yeah, so what would be the, you wouldn't see it, no matter which way it was turned.
I think you're not going to be able to see a lot of this because of the existing vegetation.
But you're going to come in from my street, right?
You will be traveling south on Route 18 and making a right down Pine Street. That is correct.
All right. I think if you could get a variance, like the Wawa has, you tell me Wawa, that was not wetlands? And they
I did not
had
work
some
on that
kind of
application.
variance
I
to,
can't comment on that.
I'm not saying, maybe you got to put
Mr.
a.
Aragoma, we
wanna
take
just
notice
clarify
of
why
your comments,
access off
but I
18.
would like to get to some other people as well tonight, okay?
Fine. Okay.
Thanks.
Thank you.
Thank you.
Who else?
Hi.
morning.
Could you raise your right hand, please? Do you swear or affirm to tell the whole truth and nothing but the truth?
Yes.
Give us your full name, spell your last.
Anne Marie Alexander, Alexander.
And Anna Marie, did you say?
Anne Marie.
Anne Marie, okay. Thank you.
Yes, ma'am.
I would first like to say I would really love for you all to take a ride by this area before you make any decisions, because they're talking about suburban caps like a commercial area, and replacing suburban caps with a 120,000 square foot, 3-story building is apples and oranges. So let's not sit here and pretend like that's all right, that's just ridiculous. I really would like you all to take a ride and look at this before you decide. And yes, it would be good to go in through 18, but they can't. So now they're gonna go in through Pine Street. Again, you have to drive down Pine Street and have a look at what they're talking about. It's ridiculous. There are 6 storage places in Old Bridge. They all have space in them. I called everyone today. If I want to rent space in any place in Old Bridge, I can go to any of them. I know it's our opinion that this is a great idea, and we know what opinions are. This is not a great idea, guys. You have to take a look at what they're talking about. It's ridiculous. It's just ridiculous.
Thank you. Who else? Anybody else?
They should put homes there. That's why it's a residential area.
Okay.
Homes belong there, not 120,000 square feet.
Sir, would you raise your right hand, please? Do you swear or affirm to tell the whole truth and nothing but the truth?
Yes, I do.
Give us your full name, spell your last.
Kenneth Edward Winters, Wintrs.
Mr. Winters?
Live on Darwin Road, 16 Darwin Road.
Go ahead, sir.
I'm concerned about it's going to lower the property value on everybody on 16 Darwin Road with a 3-story building. All along 18, I don't believe there's any further down south. I don't think there's any 3-story buildings. There is an office building, but I think it's only 2 floors. Okay? That dear building, let that building be there. It's going to lower the property value. The other problem is, like a couple of people brought up, is the water, all right? I've been there 37 years. My wife's been there about 50. When I moved in, there was a problem on Darwin Road where it would flood out down on a bend, and we'd get 3 or 4 foot of water down there, and it would come all the ways up in front of my neighbor, which is 18 Darwin Road. Where is all this water going to go for runoff? All right? And like in the back of 18 Darwin Road, there's a gully back there. And that used to fill up all the time. And it would start heading towards our property. I mean, I have sump pumps because I kept getting water in through my foundation. I had to put a whole sump pump system in. The 18 Darwin Road has a whole system put in because they had the problem too. So, I mean, putting a 3-story building there is going to cause bigger problems. It's just, where's it all going to go?
Board takes notice of your comments. Mr. Sewell, I want to ask you a question. You have the
Yes, sir.
Yeah. Would you show everyone here in the audience the area disturbance that's going to take place and what is not going to be disturbed?
Certainly. This outline is the area of disturbance.
Okay. Go up higher. Are you going to touch anything up in that area?
We cannot touch anything in this circle area because it is protected by wetlands and wetlands buffer.
So anything that happens there now is going to continue just the way it is. Nothing's going to be changed.
That's
I understand that, but you're putting.
Oh, I want to make sure that I'm right with it,
Yeah,
too.
okay. But putting a 3-story building there, it's going to take away everybody's property value on Pine Street and Darwin Road and a couple other side streets down there.
Board thanks you for your comments, sir. Anyone else? Last call? No? Okay. I'm going to close the public portion for this evening. You do have 6 people here if you're going to ask for a vote tonight.
Yeah, if I can have 2 minutes just to confer with my client to see if we want to proceed with the vote.
You're going to seek a vote tonight?
We might.
You might.
We might.
Okay.
Let me ask a question. We'll see.
Yep.
All right.
Sure. You can step outside. We're not going to go into recess. We're just going to allow the attorney and the applicants to, and the professionals to speak.
So you may vote on this tonight?
Well, it's up to them to decide whether they want to take a vote. They need 5 positive votes. There's only 6 people here. If they don't get 5 positive votes, it's denied. So the application can't be brought back in again. If it were approved on the other side, they would still have to come back with site plans, preliminary and final, a whole laundry list of other issues that what would happen. We still are on the record, so if you're going to say something, ma'am, I'm going to have to ask you to be sworn in. If you want to, you can come up now.
Well, she should wait until they come back.
Yeah, well, I don't think she's going to say anything that's really, we'll bring it up to them.
All right. She's not gonna say anything, no. Okay.
She doesn't want them.
Oh,
Just answered her question.
very good. Right, we're just waiting for them to come back in. We'll see what they want to do, and then we'll move on from there. It's already late. I'm sorry to keep everybody out this late, but in fairness, I did want to let them present their testimony tonight. We may be back on this. We don't know. Just board members, remember where you have live mics. Okay. Mr. Alfieri?
We would request to carry the application to the next meeting if possible.
I think we heard it's September?
September 4th.
That's the earliest. Is that okay with you?
Well, yes.
I mean,
Yeah.
I think that's a good decision. You should probably do that. And if you need to come back and put anything, are you resting your case or?
We may bring some additional testimony.
Okay.
Oh, if you're gonna,
Go ahead.
if you're gonna do that, you should renotice so that the public will know that there might be new
I'm
testimony.
going to tell everybody what's happening.
September 12th, you said, right?
No,
No.
4th.
4th.
September 4th. All right, for those here in the audience, the applicant, and the attorney who's presenting the application has determined that they're not going to take a vote tonight. Therefore, this matter is going to be reheard in the sense that there'll be another appearance by probably the professionals. They may supplement the record, or they may not, or they may at that time come back and ask for a vote. The reason is because it's a majority vote, it's supermajority. They need 5 of 7 votes in order for it to pass. So tonight, there's only 6. And as I said, if 2 people voted no, this would be over. So this matter will be continued, and it will be continued on the agenda for September 4th. If you forget, please go on the website of the township, look at Zoning Board of Adjustment. You can see the calendar right on there in the bottom, and it will come up. Are you gonna renotice?
We're going to renotice.
Okay. You'll get notices if you're in the 200-foot zone, but if you're not in the 200-foot zone and you're interested, look on the township's website, Zoning Board of Adjustment. You'll see what's on the schedule for each meeting. We meet on the first and third Thursdays, except in July, because of a holiday, we're going to meet later in the month. But this is going to be September. It'll be the first Thursday in September. Thank you all for hanging in there tonight, okay? The board appreciates your comments.
You agreed to hold the time period in which we need to make a decision,
Yeah,
correct?
certainly. And we appreciate your time tonight and staying late for us and giving us a chance to
Thanks.
provide testimony.
I'm glad we got all the testimony in anyway. Thank you all, Mr. Alfieri, and your professionals.
I don't think I've heard that, so I appreciate that.
Okay, board, I have to say to anybody in the courtroom, is there anyone here that wants to bring anything up to the board? Not for this. This matter is closed for the evening. But if anyone was sitting here for something else, I see no comments. Mr. Alfieri, have a good.
You too, Jared.
Okay, I'm going to close the public portion for the general public comments. Mr. Jasny, anything from you?
Nothing from me,
Mr.
Chairman.
Dargy?
I'm at home.
Maureen, next meeting is?
July 17th.
July 17, right? We're no, because of the 4th is, yeah, okay. July 17th will be our next meeting, and the 31st in July.
We got to close the meeting.
We have no other meetings?
No. There's no other June meeting. Wait. Right, there's no other June meeting.
No, because it lands on Juneteenth.
Oh, of course, it's on 19.
Right, okay, very good. Someone move for an adjournment, please, board.
Chevalier, move it.
All in favor?
Aye.
Aye, we stand adjourned.